PIL matter will also. There are illegal construction of the Gram Panchayat facility center inside of the state practice lordship. Lordship, despite of several approaches to the opposite party, they have not taken any action against.
Opposite parties?
Pardon to make you mention.
Give me a slip, please.
You know,
Give me a slip.
Master, I find the state need to honorable all of the honorable option.
First of all, seek consent.
I will. I will come back on Monday.
Orders. Matters under the heading for orders, item number 12.
Yes. Not mentioned बोले सर नहीं हुआ. None appears for the petitioner when the matter is called on 28/11/2024 and the matter was listed. The following order was passed. Paragraph 2, 3, 4 quote for the all right. As office note indicates that impugn order has that SR could not be made due to non-filing of certified copy of the impugn order. The writ appeal is dismissed for non-removable defect or non-prosecution. Defect has not been is dismissed for non-prosecution.
Item number 13.
13, my lord, certified copy has been filed on 11/12/2024.
In the yesterday.
Yes, ma'am. Yesterday, ma'am. There has been a delay of 219 days. This matter relates to that Molayananda City Rehabilitation Extension matter.
Lordship, we have received the copies of delay and other applications dated 9/12/2020.
You have received.
The Lordship is seeking to file an objection on for that.
Right. Issue notice.
No, they've already appeared. No. So the copy has been served. Yes, so copy has been served. What do you say? What is the delay?
219 days.
You want to file an objection?
Yes, sir.
What is your name?
SP Biswal.
So SP Biswal, Learned Counsel, appearing on behalf of the respondent, submits that a copy of the application for condonation delay as well as the appeal memo has been served on him on 9/12/2024. He wants to file. Now he plays for 1 week time to file an objection to the IA for condonation of delays. This is the case on 19/12/2024. Objection, if any, shall be filed before the next date.
Item number 14.
Petition on to the respondent, delay of 103 days. So far, respondent 4 is concerned, its notice is sufficient. As in respondent 3, the tracking data shows item bagged. So far, respondent 1 and 2 and personal fresh steps has to be taken.
Mr. K.C. Coral, additional learned government advocate, prays for how much time?
Hello?
How much time?
What do we want?
Prays for 1 week time to take fresh steps for service of notice on respondent 1 and 2. List the case on 19/12/2024. No, list the case, reopening date, reported date file.
9th January.
List the case on 9/1/2025. In the meanwhile, registry is directed to download the postal tracking report in respect of respondent number 3 and respondent number 5. Yes.
Item 15.
My Lord, I am for the DMT. This matter is regarding admission to the 2023-24 course, BS nursing. This has become infructuous.
Yesterday it was there. I think
Yes.
nobody was there, so
Yes.
we adjourned it to today. Just take the weekends. Yeah. He was there on. Oh, sorry. Oh, this is another case. None appears for the petitioner when the matter is called. Mr. R.C. Mahanti, learned counsel, appearing for the DMAT, submits that this writ application relates to which year?
2023-20.
This the writ application has been filed with a prayer for allowing the petitioners to participate in the government counseling and admission process for the academic year 2023 and 24 for BSc nursing course, for which the application has become infructuous due to passage of time. Full stop. The writ application is accordingly dismissed as infructuous.
Item number 16.
In this case, the hearing on behalf of the respondent, my lord, even though notices have not been issued, I think that this is with regard to the grant of UGC to the demonstrator who have been declared as teaching staff. And this honorable High Court has already dismissed the writ appeal in several cases.
Have you appeared or you'll appear?
I don't think I can see it can be.
No, but without your appearing, we'll dispose of.
No, I have instruction to appear. I could not file the vocabulary now, or in identical matter, there are several matters are also
Unless
there.
you appear, how can?
I will have a glance.
We have 416
The
days.
lordship in the other
Is
cases.
covered by that judgment, ma'am.
Yes. This has been approved by the Supreme Court also. Several cases your lordship have disposed of. That is the reason I want to place the matter.
Yes, you are saying that it is
Yes. In light of that, it may be disposed of.
in light means. Light means it is already covered, so that will be dismissed.
Your lordship has dismissed the writ.
Submission has to be submitted. Mr. K.C. Kaur, learned additional government advocate, submits that concedes that the state order is that the order passed by the learned single judge in WPC number 30007 of 2022 has been challenged, whereby the said writ application was dismissed in the light of this court's decision dated 18/4/2022, passed in WPC number 26692 of 2011. Full stop. It is, he also submits that the order dated 18/4/2022, passed by this court in WPC number 26692 of 2011, has been affirmed by the Supreme Court by order dated 10/10/2022, passed in SLP bracket civil diary number 22626 of 2022. In such view of the matter, dismiss both. What is the delay?
And a delay of 416 days.
So in such view of the matter, we dismiss the IA for condemnation of delay, and consequently the writ appeal challenging the order dated so and so passed in WPC number 30007 of 2022. Yes.
Kindly ask them to comply the order. Because in other cases, payment has already been made. Because of the pendency of the case, they are not complying. I don't know.
Next.
Time limit like it. And
Item 17.
another case is identical to that is writ appeal number 414 of 2024 is identical. May I pray, my lord, it can be also listed next week or any day it can be listed.
Ask your junior, someone to make a mention.
My prayer is to fix a time limit so that they also comply. Because they are retired since long.
Yes, next.
Item 17.
That's in item number 17, there is a delay of 274 days and 1 week time may be granted for obtaining certified copy in this matter.
Okay, so this has been listed for the first time.
First time, my lord.
What is the subject matter?
Issue is the direction was given by the learned single judge to observe the
Absorption. 1 week time. Ms. Aishwarya Das, learned additional standing counsel, prays for 1 week time to file the certified copy of the impugned order. This is the case on 19/12/2024. Concerning the said prayer, list this case on 19/12/2024. Oh, sorry, IA is accordingly, the IA is accordingly, in a prayer for 1 week time is granted to file the certified copy of the impugned order. The IA is accordingly allowed and disposed of. The certified copy shall be filed within 1 week as undertaken. List the case on 19/12/2024. Yes.
Item number 18.
This matter has filed one intervention petition, your lordship, near the harbor chassis. When we are cultivating that land since long, but that is I have filed one idea.
This has come for condonation of
Lord,
delay.
I pray time to
No reply has been filed despite my lord's order.
I
What
pray
is the delay?
There is no delay as per, because I received the information from the Tahsildar.
What is the delay shown by the stamp recorder? Then you give your
As shown by the
explanation.
registry man.
All right.
Lord, I file counter to the petition of limitation because the month is at Ajodhya.
Which month?
The opposite party is at Ajodhya. He will return during the end of this
Which item?
December. I pray
18. He'll return today.
Just a minute.
end of December month will return. I will file counter to the petition limitation, including the
How do you say that there is no delay?
My lords, I was not a party in the writ petitions, my lords. I received information from the Tahsildar that this contempt is filed pursuant to the order of this honorable court in this writ appeal. So immediately I, my lords, filed the writ appeals being affected party.
How are you affected?
My land has been, my ownership and land is in questions, my lords. The temple administration is the recorded owner as per the RR published, my lords. The Mahanta wants to set aside that ROR. In the
why
first
did you not-
limitation record, my lords.
Why did you not include him party?
no one. What happened? The sub-collector come asking settlement of the consolidation officer. He has passed the rescind order. And Puri temple did not cooperate also.
Did
That
not
is,
cooperate.
did not cooperate nor appeared also. Thereafter after that thing,
Why have you not filed objection?
Mohan is there to Ajodhya. I will file the counter explaining all facts.
We are condoning the delay because he was not have you filed any application for leave to appeal?
Yes, ma'am.
Year number 8454.
Yes, ma'am. 8228.
Man, I pray.
8228, ma'am.
After Xmas month, I will file the
No, you.
counter.
All right, you file and we will give you liberty to contest the writ appeal.
Yes.
The IR number so and so has been filed.
8228.
Q8 has been filed on behalf of the appellant seeking leave to appeal. It is the appellant's case that the appellant was a necessary party in whose name the ROR was recorded. Without impleading the appellant as party respondent as an opposite party, the writ application has been filed. The writ application was filed, which has been allowed,
Yes, ma'am, disposed of.
which has been disposed of by the order impugned. Considering the facts and circumstances, IE number so and so is allowed. The appellant is granted leave to maintain this intra-court appeal against the impugned order. Stop. Next, IE number so and so, condonation of delay.
2999.
2999. Stop. The impugned order was passed by the learned single judge on
18/7/2023.
18/7/23.
18/7/2023. It is the stand taken on behalf of the appellant that the appellant was not aware of the said order passed by the learned single judge. First of the moment the appellant learned about the said order passed by the learned single judge, the present writ appeal came to be
You have
filed.
stated that in the IA.
I have stated the writ appeal, madam. So I have taken averment in the writ appeal as a part and parcel of the IA, madam.
They have preferred on one appeal also before the learned idea comes
Despite opportunity. Shut up.
That is.
Please,
You will get a chance.
please keep your mouth shut.
I am submitting.
You will get a chance.
The despite opportunity granted to the opposite respondent and contesting respondent, no objection has been to the application seeking condonation of delay. Of learned counsel for the petitioner, for the respondent seeks further time to file objection to the application seeking condonation of delay. So stop. In the fact, how much time do you want?
Within December, I will file.
Whenever.
After the expunction, I will file.
So
January, first week of January, I will file.
he submits that he shall be filing objection in the first week of January. First of the prayers so made on behalf of the respondent is apparently unreasonable. First of be that as it may, he is granted time to file an objection. First of in the meanwhile, the operation of the impugned order shall remain stayed. Let's this matter on. Yes, do it. And we are imposing costs subject to payment of a cost of rupees 10,000. Filing objection. File objection, pay 10,000.
You will pay the cost.
You will have to pay 10,000 for filing objection.
My poor Mohanta, having no.
Let him be poorer. Let him be
I
poorer.
say no cost, my lord.
Yes, cost.
Because my lord, it is a.
We understand so many things. Pay cost, file your objection.
Item 19.
Your lordship, I cannot insist.
No, it is up to you. We've asked you to pay cost in case you want to file objection.
No, I will file.
Subject to payment of cost.
Item number 19.
I pray may kindly may not be penalized my. I am submitting. It is up to your lordship to.
That we have done.
Item number 19.
My lord, the sole respondent has appeared, entered appearance, my lord. There is a discase filed by them that the delay of 271 days. I file objection with that. I will reject it.
All right.
Mr. J.K. Rath, learned senior counsel, submits.
Along with the end of.
Have you appeared or you will appear?
I have appeared through the end of.
When?
Already we have.
When?
Yes, for the sole respondent.
Mr. J.K. Rath, learned senior counsel, submits that he and his associates have entered appearance on behalf of the sole respondent Full stop. It IA condemnation delay. All right. He prays for 1 week time to file an objection. He prays for 1 week time to file an objection to the IA for condemnation of delay. List the case on 19/12/2024 along with the objection. Yes.
Item number 20. Item 20, we have not been able to file a certified copy, or that may 1 week time. Within that period, I will.
Mr. Bimbisar Das, learned additional government advocate, prays for 1 week time to file the certified copy of the impugn order. The prayer is allowed. The IA is accordingly disposed of. Certified copy shall be filed within 1 week as undertaken. Full stop. This is the case on 19/12/2024.
Item number 21. 21, my lord, delay is 171 days. Objection by non-friend is filed.
Yes. First one to last one.
Yes.
Basing on the repeal granting, issue is, my lord, basing on the repeal granting at order 1994. Direction has been issued to extend the benefits. That has been challenged in the writ appeal.
And the only ground one is the limitation person para 4. Nothing has been stated. But after receipt of the order, government has decided to file, there were delays of 171 days cost.
But here you file the certified copy.
Certified copy has been filed.
Yes. Last order also kindly.
Objection. Yes. All right. So 5971. No, 5705.
705.
5705. Paragraph 4. Heard Mr. Bimbisar Das, learned additional government advocate, and Mr. Sangram Jena, sole respondent or respondent 1?
No, all respondent.
How many?
Respondent total mallet 1, 2, 8.
Yes.
Mr. Bimbisar Das, learned additional government advocate, and Mr. Sangram Jena, learned counsel appearing on behalf of the respondents 1 to 8. Full stop. Considering the reasons assigned for the delay in filing the appeal, we are satisfied that it is a fit case for condoning the delay in filing the appeal in the interest of justice, but subject to payment of cost of rupees 5,000. 5,000 hale manti habo? There are 8 respondents. 1,000 is- There are 8 respondents. Subject to payment of cost of rupees 1,000 to each of the respondents. The cost shall be paid within a period of 2 weeks. 1 week.
2 weeks.
Within a period of 2 weeks. List the case for fresh admission on January
9th.
On 9.
Also already last order they have directed to take this matter in the matter to if the writ will file against the order.
Yes.
All right.
Yes.
Also already,
Yeah, you're right.
yes, last order also already pointed out.
Name. Correct.
Because the other matter already referred to the library.
No, one matter has been referred to
Yes,
the
and-
larger
yes.
bench.
And that also already indicated in the last
So it
order.
should be. Okay.
So let that be decided.
List the
Let
case.
me question
That
this.
will cover. That judgment will cover certainly.
List the case on 9/1/2025 as mentioned in order dated 5/12/2024. WA 2047 of 2024. Labba Kumar Rath versus State of Odisha, where the order of the order passed in appeal.
Yes, if you
24C or what?
20%.
Where the order passed by the learned State Education Tribunal in that was under 24C.
Yes.
Order passed in an appeal under section 24C of the Education Act had been challenged before the learned single judge and has been challenged before the single judge, and the order of the learned single judge has been challenged in the writ appeal. So 9-1 रे था वो यदि in between हेगला fine
In the meantime, the division based order, depending on which the writ will help will maintainable, that was also challenged with the Apex Court. Now the Apex Court also issued notice in that matter.
All right, we will decide.
Right.
So what is that case number?
Else of the writ of
Yes.
SAP number.
All right.
Item 22. 22, my lord, in this case, on the last occasion, your lordship wanted me to take instruction as to whether the appellant, they're willing to pay 1 lakh cost, because the delay is 1,055 days. Would your lordship be kind enough to grant me 2-3 more days, and that officer I was consulting, he is on leave. That is, this morning I got him.
All right.
As Mr. Bimbisar Das, learned additional government advocate, prays for an adjournment to obtain instructions. This is the case on 19. 19. Next week is 19.
Oh, yes. 19.
On 19/12/2024.
Item number 23. 23, my lord, there has been a delay of 54 days.
You are not the appellant.
I am not the appellant. Sorry, sir. I should not have submitted. I am a bit.
No, it is possible to get confused because he also could have filed it on behalf of the state.
Yes, in the last paper, also you see the order date 27/11/2024. There, my lords, I issued, you also issued notice
But where is Mr. Mahapatra? He was contesting the maintainability. You are there.
on behalf of Mahatma.
Yes, you are there. Okay.
Respondent. Delay 54 days.
Yes. So registry is directed to download the postal tracking report in respect of respondent number 6 and tag it to the record before the next date.
Item number 2.
My lord, from my lord direction regarding that migration matter, previous admission. I had received yesterday evening the hard copy of the counter. This file. Because this is posted to today, I have given them copy. Yes. And stand is that in 1997 in NCAR, there was a regulation from Irish. But in 2013 regulation of the National Medical Commission, which has been superseded by the of the MCA, there is no migration is allowed. That's why, though the recommendation has been given to us, we have denied by a letter that is in the annexure that we cannot allow. But it says
Issue direction against law. If there is any bar, the court will not do it.
But is there any bar?
oh, because we don't have.
There is no provision for migration, but is there any bar?
It was previously with the Medical Council of India, but I don't know how the National Medical Commission has. The regulation I have already given. Case 13.
A/3.
Case 13.
Yes, my lord.
Yes.
Para 18, my lord.
Oh, there's a bar.
Yes.
Students.
Cannot do it.
Yes, my lord.
Lordship, can see the recommendation given by DMT.
42.
Recommendation given by?
DMT. AC Medical College has given the consent. Shijanath has
That is
given.
not the question, Mr.
I mean,
Counsel.
that is true, my lord.
We-
Only on a humanitarian point of view, DMT has
Humanitarian-
recommended, my.
See, on humanitarian
But the
aspect, we are
life-
there we are there with you, and therefore the matter has been listed at the top today.
Life has risk, my lord. That is why only treatment facility available at AC Medical College.
We do appreciate, but what can we do? Can we pass an order contrary to law? In any case,
It may not be creating precedent, my lord. Lordship will like save the life of a young boy of.
we are inclined to do that, but we can't. Your commission does something. The commission may be having such power. But if there is a specific bar, how can we deviate from that?
So this affidavit you file on behalf of Medical
NMC,
Commission,
National Medical Commission.
You have filed this on behalf of National Medical Commission.
which is that paragraph where you have dealt with that?
National Medical Commission, what can be done?
Para 6, I have already told about that 1997 NTA regulation. There is continuity in para 7, 6 and 7.
Very difficult, Mr.
So when did the new regulations come into force?
2023.
So he is admitted since when?
22, 23 session.
20?
22, 23 session.
So before the new regulations come, he has been
Yes,
admitted.
Where are those regulations?
Here one.
Regulation second. Second from 2023.
No, this we have seen, but where are the old regulations?
Have you given that? No. That was 6 there. That was 6 of the counter action. It's only thing that this actually regarding admission, regarding some other college, not
Yes,
because
yes.
of this.
Yes, there is a
So
provision.
it
How
says
they-
1 month.
There was a provision.
Here.
When did he apply for migration?
That is recommendation given under an answer for one by the medical board. Thereafter, immediately thereafter, that an action investigating.
Joined in 2022-23.
23 session he has taken action.
So you have that. That means you have not passed.
First year I have passed. Second year continuing my level.
Because
Migration only was allowed in second year only. In
Sorry?
1997 regulation, it was allowed after 1 year. Second year, there was the migration only.
Only second year they will consider. For third year, there will be no.
It was.
So do you have the 1997 regulations? It must be there in the book. Let us think over. Give us the 1997 regulation.
After lunch, I will.
See, there is no repeal or saving thing in the. Filed it in the registry and we will see.
Yes, Masha.
So that can be brought up.
Yes. I'll file the resolution also.
I'll run counsel for the.
That with the memo along with.
Yes.
When counsel submits that he is going to file an affidavit on behalf of National Medical Commission
Yes, ma'am.
in court of the day. Let it be done. Discuss this matter on Monday, Tuesday. Let the affidavit so filed. Till the affidavit be filed, be scanned.
Item number 1.
Judgment, my lord, they want to be incidentally add of the quality council there. It is entirely covered. The circular came subsequently, the petition was promoted to TG. Prior to that, the circular says that it will be given from an earlier date. Your lordship has said that why to do deny the benefit to those persons.
You will have to incorporate facts. The
Sorry, ma'am.
impugned order, in the impugned order, the facts have not been incorporated. Therefore, we had to write,
The facts, what I find in the judgment, that is when.
facts are same.
Facts are
Same
all.
answer. Only issue is that whether the classical teacher can you grant a PG scale? So that,
That is the law, that is the principle,
well,
that is the,
this is the faction.
It's,
this is the fact.
facts are same.
Same idea. Here, the teacher
You
classical.
were appointed as classical teacher on
Teacher.
1/3/1990.
No.
Yes, classical 90, they are almost
But
26.
they,
19.
Appointed as a classical teacher in 1982. 90, my lord, he was extended trained graduate scale of pay. Thereafter, in 6/6/2006, the respondent was promoted to junior SES, junior subordinate education service post, cadre. Thereafter, the circular came 5/9/2011.
only appointment as classical teacher, there is a difference in the date.
Date.
So when were you appointed? Huh?
I appointed on 1388.
Say 82, Mr. Das.
Our document says 15/7/82.
Then 88, the 82, the 88 the school was notified to see country. From that, they are counting service. It took the appointment, but
And yes, appointment is 82.
up to the 88, madam.
Yes, that's what I don't dispute.
That is the answer. Same
When
issue.
did you retire?
Retirement 2000.
39/2019.
13?
39. 30th of September 2019.
Iris.
It is not.
Iris,
Or 30,
2019.
19.
So did you file a contempt application?
Yes, it's contempt of my job. Because
When was your representation rejected?
difference of court allowed the case. Allowed the case, I filed contempt. Thereafter, my lord drop the contempt because condition this repudiate the bill.
You are showing us this order
My lord.
and you want us to pass this order. So there are certain,
Dates are.
Dates are,
who will do that?
I'll do that. Sorry, I'll do that.
Let us do.
Paragraph 4. Paragraph 4.
Four I have done, paragraph six.
4, paragraph 2. 2482 of 2017.
15/12.
Paragraph 4 impugned order is the same.
No, can't be.
What is the date of the impugned order?
15/12.
15/12/23.
22, madam.
Impugned order.
Madam.
Dealer more than 500, the cost control by imposing cost.
Yes. WPC OSC.
Madam.
2482. 2017.
Let's do it.
I'm doing.
Yes, next.
Case admission item number 3.
In this case, there was delay of 24 days. Your lordship issued notice and limitation. Notice is sufficient. There is direction to see if any advocate has appeared for. Nobody has appeared so far. So that's it. That is really regularization of DLR help.
I don't get that even a person can say, oh, like a paper. So you confident that how much
The respondent, despite service of notice on the, despite service of notice. Stop. Does this matter? 4 weeks.
Item number 4.
There is delay of 547 days. Notice was issued. No counsel appeared so far.
Come out of service.
Yes.
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 Item number 5.
Delay of 543 days, my lord. No counsel also appears.
What is the point involved?
My lord,
What is the point involved?
What is the point involved?
point involved is senior TV laboratory definitions regularization matter. The question is, he has had a educated study in an institution which is not the AICD recognition matter. On account of that, we have challenged.
This is Raman Procedural. Mahapatra.
Whether what happened to this case? Akhil Kumar Nayak?
The Akhil Kumar Nayak case, my lord, that is covered by the judgment. That is where, let's see, I have not examined the judgment. Let it
No, whether Akhil Kumar Nayak judgment is under challenge.
Yes.
Yeah.
That is, then that whether we are challenged or not, that is no issue, information about it. But
The
it is covered by-
the order which you are challenging is based on an order passed in case of Akhil Kumar Nayak.
Yes, my lord.
And you don't know whether this Akhil Kumar Nayak.
But yesterday file came, I have not examined. Today I will examine that.
जितना भी मैटर है 4 weeks रखे Monday Tuesday Wednesday करो Wednesday. Please examine what happened in that case. देखो अक्षय कुमार नायक
18th, no?
अक्षय कुमार नायक इसमें PC 33301 of 2021 and 20, sorry.
I will examine it, sir.
So this is 18th.
Well,
Can you write something like that?
no, we want to know. Yeah, Akhil Kumar Nayak. Akhil Kumar Nayak appeal as a right. 4 minutes. An order passed by the single judge of this court dated 11/12/2021 passed in WPC number 904 of 2021 is under challenge in the present intra-court appeal. First off, it appears from the said order that the writ petition has been disposed of by the learned single judge in the light of the judgment delivered in case of Akhila Kumar Nayak and others versus State of Bihar, WPC number
State of Orissa.
State of Odisha and others, bracketed WPC number 33301 of 2020. Learned government advocate is not aware as to whether the main judgment has been in case of Akhil Kumar Nayak has been challenged by the state or not. So list this matter on next Thursday for him to inquire and inform this court as to whether any intra-court appeal has been preferred against this judgment or not. Yes.
Item 5.
Same.
That's right.
I will same light, my lord.
And batch kar dena usko. Akhil Kumar Nayak and batch. File same order.
Item number 6.
Item 6 is option. Last notification confirm the delay. But they're shown the copy of the appeal memo on 2nd of December year. Actually, what is the instruction over the matter?
As requested on behalf of the respondent. Discuss matter on how much time?
2 weeks.
2 weeks. Yes.
Item number 7.
I have given this not submission.
I don't know supposed to argue and supposed to assist. Were you not supposed to argue the matter?
Yes,
You're not ready?
Yes.
And this is an ex parte inquiry. No complete violation of natural justice. The petitioner is a head constable. Charge sheet was issued. He has beaten to the sweeper constable. And his CBSE examination was there. He has applied for leave. Leave committee has approved the leave to be granted, and that was not allowed. He has left the headquarters without permission. And there he failed leave. He has given the application with the medical certificate that is not considered. An inquiry proceeded ex parte. All the notices were served in the headquarters at his home address. Inquiries were conducted completely ex parte, and there he also received another charge sheet that left abandoned headquarters without permission. My lord, the only sole ground of my submission, my lord, is absolutely I have no opportunity to examine the witnesses, all the witnesses, and immediately after joining, I was I prayed for. My joining report was accepted. I was allowed to join and attend the inquiry. Inquiry officer didn't allow me to participate in the inquiry, not the fresh witnesses. And thereafter, I was directed to submit the defense, written defense and punishment and reasoning. Whole judgment also I have brought your lordship's attention that also. I have-
When did you receive the charge memo?
Charge memo received and the inquiry was conducted. Complete inquiry has been conducted, inquiry report has been submitted, and the report after the report, punishment has been imposed. Punishment that is under appeal and revision rejected, appeal revision both rejected, thereafter single bench.
When did you receive the charge memo?
Charge memo, my lord, that
14th February 2017.
What did you
Was
do
this-
thereafter? Just a minute, Mr. What did you do thereafter?
my lord, preliminary inquiry was held. The
When did you receive your charge?
charge, my lord, I have received my lord 14/2/2007.
So what did you do thereafter?
Thereafter submitted the reply
Submitted. Where were you when you submitted your reply?
in the office, in the headquarters.
All right. Then what happened?
Thereafter the preliminary inquiry was held.
Yes.
Preliminary inquiry, I have also said, preliminary inquiry, I have stated that my daughter's examination is 4 on 4. I have submitted the leave application for 20 days. Thereafter, I will attend the inquiry. That is also there. They have recorded my statement. Other statement also there. They have didn't supply the inquiry report. Thereafter, on the leave committee has approved the leave application and also instructed that he will be given leave. And I have purchased the ticket also. And ticket also I have purchased. The still commandant didn't allow and they wanted the inquiry should be completed. Thereafter only leave will be granted. But they didn't allow and I have left the headquarters on 3rd.
Without permission.
Without permission. That was the case.
Then when did you
And
return?
thereafter,
All right, you left the headquarters
left on the headquarters.
without
Reached at
permission,
home
but
on
when
seventh.
did you return?
Return minor 20 days leave I have applied. After going there, I fell ill. My daughter examination center was 70 kilometers away, and myself and my younger son. My son actually he was reading in class 7.
When did you return?
Return minor 59 days or 39 days overstay.
All right. In the meanwhile, what happened?
Meanwhile, they have sent notices to my home address, and I have a home address through CISF.
Whether inquiry was held in the meanwhile?
In the meantime, inquiry has been held.
The witnesses were examined.
It was regular. And I have said that immediately I am joining, I will attend the inquiry.
When was the inquiry report submitted?
Inquiry report, my lord, submitted.
Is this question irrelevant? The question which I put was irrelevant. It is relevant. And you don't know the date.
5/6. Five, 6, 2016.
So you received the charge memo in 2017 and the inquiry report was submitted in 2016. It is evident that land counsel for the petitioner is not at all ready to argue the, not at all prepared to argue the matter. This case on 8 weeks.
Item number 8. Please, my lords. My lords, I'm for the petitioners and I'm begging leave to appear on VC. May I inquire if I'm sufficiently audible, my lords?
Yes.
Please, my lords, this is a case filed by an organization representing the Fair Price Shop Dealers Association within the state, my lords. And this case concerns the complete ouster of individual fair price shop owners from the framework of the National Food Security Act. And my lords are aware that historically these individual fair price shop dealers have been the backbone of the entire framework. And these individuals, my lord, for decades have held these particular licenses. But by way of two control orders, one being a central control order of 2015, and I will take my lords through it, of course, and a state control orders in pursuance thereof in 2016, my lords. The government has decided to give preference to institutional fair price shop dealers to the complete exclusion of individuals. We are impugning these very provisions, my lords, on the basis that it completely affects our livelihood and that we are not given.
Must have been decided by some of the high courts.
Yes, my lords. I'm very grateful that this has been put to you, my lords. There is one particular decision. This was first taken up by the Honorable Allahabad High Court. My learned friend, Mr. Sachin Sahu, will kindly hand over the case. This was by way of a writ petition in 2021. In case number 16086 of 2020, this was a batch of writ petitions, my lords, which was taken up. And my lords has it. This was decided on 24th May 2021. To our attention, my lords, this is so far the sole decided case on the issue. We understand there are a few other petitions which are pending across a few other high courts. But this case was decided and this struck down the vires of these very provisions, my lords. Would my lords prefer me to take you through the statutory provisions first before I get to the case?
What has been declared ultra vires?
My lords, what was impugned principally, my lords, the exercise of these powers flows from section 12(2)(e) of the National Food Safety Act, which says that a preference will be given to public institutions or public.
Same order.
We would prefer the same order, lords.
Want the same order? But
yes,
the order has been passed. The order has already been passed by Allahabad High Court. So why should we pass?
Yes, my lords. I'm again once very grateful for this question, my lords, because in this particular writ petition, and there is also a cognate writ petition filed prior in time before this very honorable High Court, we are specifically impugning the Orissa state control order, my lords, which was not subject matter of the other petition before the Allahabad High Court. Can I please take my lords through that?
Yes, you are appealing for the state. Have you examined?
No, my lords.
All right. When do you want?
My lords, 3 weeks time may be granted.
Yeah. Let's just matter on 3 weeks. Have you filed any affidavit?
My lords, in this
has been taken up for the first time.
First time, my lord.
All right.
My lords, it's also my duty to inform that there is another writ petition filed previously. But what has happened is subsequently there are various notifications which the authority has issued, whereby they are the fresh vacancies and licenses which are being issued are to our complete ouster.
Listed on 4 weeks, along with
WPC number 34998 of 2022, man.
That is correct.
which according to run for the petitioner involves similar / identical legal issues. Yes.
998 of 2022.
Is it pending?
Yes, ma'am.
Yes. Last heard in May 2023, it was last listed.
Yes.
I'm currently requesting a stay of the impugned notification at Annexure 5 in the meanwhile.
Not now. Yes.
In the other matter, we were granted a stay. If I can at least request a similar interim status quo in the meanwhile.
Not now.
Very well. I'm deeply grateful, my lords.
Item 9.
Sole prayer in this case, petitioners are directed to the state authorities to ensure construction of Hamo bus stand at Raike district of Kannamar. That is under Annexure 2 ROR, that is in the name of the Road and Transport Department. Annexure 2 is the ROR in the name of Transport Department. And there is a policy direction by Annexure 1. The Raike name is there reflected at serial 68, my lord. Annexure 1 resolution.
Who will decide?
But the district level collector is the district level committee head.
Let them decide.
Yes, madam.
Why the court should unnecessarily involved. in
Some
the
obstruction are there being there.
Construction, they will look into that.
That is to look into by the collector.
In the present writ application, file PIL,
Yes, ma'am.
file in the nature of public interest litigation. The petitioner is seeking a direction to ensure construction of Ama bus stand bracketed serial 68
Yes, ma'am.
of phase 2 list bracket close at Rakia Kandamal over OSRTC land under land. First off, the petitioner has given the details of the plot over which the said bus stand should be constructed. So next, our considered view. In a proceeding under Article 226 of the Constitution of India in the nature of public interest litigation, this court should not entertain such prayers which are such reliefs. First off, the location at which a bus stand should be constructed is purely an administrative matter. Stop unless violation of any statutory provision, a legal right or a fundamental right is established, this court should decline such relief. Stop accordingly, this application. In our view, this application has no merit and is accordingly dismissed.
Let me be disturbed. There the complaints of the
Item 10.
that could be disposed of by the collector according to the police decision. That is Annex 1.
Item number 10.
My lord's order has been complied with, my lord. We have filed complaint affidavit yesterday.
Yes. Complied with. Finally, complied with.
By virtue of the order, pursuant to the order dated 5/12/2020.
Yes, on it, complied with. Yes. Oh, I thought this.
The next matter.
Item 11.
Next matter, just few minutes before, I received the instruction that yesterday, Honorable CM has approved the file. Today, the posting order will be issued.
Tomorrow,
I really don't understand your lordship. On the last occasion, he said the process is on.
Yes.
Your lordship may kindly see the direction given by the Honorable Court. This Honorable Court directed.
No, let them
Let them file it, your lord.
Let them file it and then we will.
Only thing is that my appellant, we are the 5 appellants who have been discriminated and we are also agreed.
Posting order will be issued today. We will be filing compliance affidavit in the meantime.
As requested on behalf
1
of
week,
the
your lordship may kindly.
opposite parties, list this matter on 1 week. 1 week. Huh?
Because they will be filing the compliance affidavit.
1 week, yes.
2 weeks.
Or 2 weeks, 2 weeks, 2 weeks.
We'll file affidavit.
So as to enable him to file compliance affidavits.
It toiled hard in this case for 3 months. It was kept and there.
No, it was.
And now it is 6 months.
And we are complying with you, Lord. We are complying. Today only posting order will be issued.
For admission, item number 24. Item 24.
Lordship, kindly look to order number 10 dated 23/9/2024. In terms of that order, I prepared the paperwork. Shall be submitted.
Order dated?
Order dated 23/9/2024, order number 10.
Yes, yes.
I prepared the paperwork because of the volume. Several affidavit, counter, agenda, booking.
I prepared this paper book for your lordship's convenience.
Napoleon not there.
And the appellant is not there. I am the respondent. I'll serve a copy to my learned friend also.
Intimidating.
I have also given the date chart, date out of the ways. During the course of hearing, lordship found out.
What is the issue involved? Let us understand.
Yes, yes.
What is the issue?
Issue is now a trust. There was a dispute between some of the trustees, and ultimately matter was carried to this honorable court in the second appeal, arising out of civil suit. And during the pendency of the second appeal, a receiver was appointed, collector was appointed receiver. And at that time, an institution was running, an engineering college was running. And ultimately, this honorable court at the instant dismissed the second appeal and we succeeded. The trustee and directed the collector to hand over receiver to hand over the entire charge, including all fixed deposit to the present trustees. Then thereafter the collector handed over. And after handing over the collector, the government also directed that the governing body is to be constituted. I was also, the trust also managed the institution by the order of the government. And subsequently, different banks also released the fixed deposit, except this bank. So we approached this single judge. Single judge allowed our application, directing the bank that they will give the indemnity bond because the collector had not handed over the fixed deposit receipt. So indemnity bond in terms of the RBI guideline, and accordingly we have handed over. But in the meantime, they moved this honorable court division bench and an interim order was passed. So you also wanted to know what is that trust and everything.
Who is for the appellant?
Yeah. We also call it sometimes either next week or after vacation.
Who is for the appellant?
Well, the appellant is the way and the still coming. It will be after lunch.
He is still coming.
Minus.
All right.
So call it sometimes. I'm also serving a copy to
Behalf of the party, discuss matter on after already discussed.
Item number 27.
Yes.
27.
You are for the other side. This is regarding what? Matter has become infructuous.
Yes, yesterday it was there. We had adjourned it to today to enable the council to take instructions because Ms. Pamirat was not there. Junior counsel was appearing, so we had adjourned it to today.
Admission for the session
23-24.
There is no representation on behalf of the council, appearing on behalf of the
Number 3
and 4 has submitted that this application has become infructuous as the issue relates to admission to pharmacy courses for the academic session 2022, 23 and 24. The date of which has expired long back. Cut-off date for which has expired long. This application is accordingly dismissed as having become infructuous.
Item number 28.
Lord, on the last occasion, the lordships had asked me about my case and having regard to the opposite party, having done all the wrongs, they have no right to claim any legal provisions that is taking undue advantage of their own wrongs. On this ground, and on the grounds of the orders of the Honorable Court dated December 2001 till 11, I will say this appeal of the bank may be summarily rejected with exemplary clause. And I am obliged greatly to this Honorable Court. The other day, when the lordships have expressed that exemplary clause really have to be imposed on the bank for their such of actions. And my lord, regarding my appeal for my financial benefits, I have 3 issues raised. First, grant of salary allowances by upholding the promotion to scale 5. Second, for fixation of salary and promotion in appropriate rate, according to my seniority, and further grant of exemplary compensation for the harassments and infraction of my rights. But the honor single judge has put 2 questions to be answered and decided. The first question was regarding promotion, and the second was for benefits. When the first question has been decided favorably, the second question of benefits has been not considered rightfully on the lights of the decisions in Pradeep Sound Rajkumar Jain versus Manganese Ore India Limited and CAG of India versus KS Devanathan and also KB Rajoria and versus Union of India. In this case, no work, no pay has not been considered because no work, no pay has evolved that when the employer has restricted the employee to perform, then this principle cannot be applicable. But as explained earlier, the opposite party bank have deliberately done some mistakes. This is mistakes of law, not mistakes of facts. And these are specific and direct intents. This is also deliberate and contumacious disobedience of the Honorable Court's order. And taking this in view, I pray before my Lord that this is a court of justice rather than court of a mere law. And equitable justice means equal justice to all parties. And I have lost so many things in my life. For the last 20 years, I am suffering. And I have lost up to 50 lakhs in my salary. And I have the other day, my Lord asked me about my career, my year of marks. I have given in my additional affidavit before this Honorable Court filed on 5 September 2022 at Annexure 42, 41, 36 to 41, page 66. All my ARF scores are 100% and above those who have been promoted in the meantime, my juniors and my counterparts. And having said all this, this is also another fact that I have come to this court. When I came to know, Annexure 19, they have said that we know how to implement court orders and the court cannot do what we don't want. This is what I've said. I refer you for the Chief Justice, then Chief Justice, that is recorded in Annexure 19. And when I came to know about this, on several occasions, when I saw that my rights are violated, I came to this Honorable Court's feet to seek my rights and interests through my ideas and cases, which could not have been considered by the court till the final order on this February. So I pray, when I have come to this court for my protection of my rights, the Honorable Court should consider my case favorably, and for no part of mine, I should not have been deprived from the benefits, the fruits of my employment. That is my submission, my Lord. And lastly, justice and equity would need to mold the relief. That is my only prayer, my Lord. And I believe in the saying, Dharma Rakhyate Rakhita. I have shared my Dharma. I have time and again come to this floor of this house, this Honorable Court. So the Honorable Court should now need to do the Dharma as in the temple of justice and protect my interest with promotion
salary allowances, right pension, and adequate amount of compensation. Because my lord, this opposite party banks, they are now behaving a lion, a tiger out of the case, in the case. Now, if any leniency, any leniency is given to them, they will again become the tiger out of the case and will chase. Innumerable examples are there, and they will chase like this and harass me and harass others. So, exemplary compensation fixed. Let it be recovered from the persons who are responsible for this, those who are narrated as opposite parties. That is my sincere prayer, madam.
Yes. Your submission is over.
No, they say something. And they pay your lordship's permission. If there is something in there, I may counter.
And why did you start?
Madam,
Why did you start?
why did you start? Well, you Lord asked me to start. I'm sorry, madam, I could not.
Yes.
The reference was made to some affidavit which he has filed. The copy of the affidavit is
That we will not look into. We shall not look into any document beyond those
Okay.
which were there before the learned single judge.
absolutely. Right. Just to recapitulate on what I had submitted to your lordship the other day. He had joined in 1982 as a clerk. In 1998, he took the examination for coming to scale 1 officer. He succeeded in that examination. Now, a few dates are important. On 1/8/97, he succeeded in the examination to be appointed as, to be promoted to the post of JMGS 1, say scale 1. On 7/10/98, he gave a letter to the bank to forego his promotion. On 11th of January 99, the bank allowed this representation. That, all right, you forego your promotion, you go back to your position. Thereafter, on the 20th of January thereafter, he withdrew the representation made for foregoing his promotion. Now, once he withdrew, this withdrawal was rejected by the bank. He came up before your lordship in 2001. That is, after a gap of 2 years, he came up before your lordship. Your lordships, during pendency of the writ petition, said that let him appear in the promotion test and the results be kept in a sealed cover. And ultimately, your lordships were pleased to allow the writ petition, saying that no, his withdrawal should not have been taken into consideration. He should have been allowed promotion. So he will be deemed to have been promoted to the post of JMGS 1, but he will not get the financial benefits. Now, simultaneously, the bank opened the sealed cover. The seal after disposal of the writ petition. In the sealed cover, it was found that he was unsuccessful in the promotion examination to the level, next level, that is level 2. Thereafter, he continued in the position of JMGS 1. In 2014, thereafter, he made a representation that I be promoted because my juniors have in the meantime been promoted. So in 2014, he filed another writ petition saying that I be promoted. In the meantime, the bank has given him not 1 but 3 chances. Those chances were given in May 2014, August 2014, and January 2015 to claim promotion, because as per the policy of the bank, he had to go through this procedure. He did not appear. He did not appear in the examination for promotion. Thereafter, this writ petition was taken up for final hearing.
As I pointed out to your lordship, that he was in JMGS 1. And the court, while adjudicating, held that yes, the bank has wrongly withheld his promotion. He should have been allowed to be promoted, even though the policy is on the basis of seniority come merit. But the court considered his case and gave him promotion to level 5. Now, my grievance is there. He is in level 1. He may be promoted to level 2. But from level 2, level 3, level 4, and level 5, each of these steps entail an appraisal on the basis of his not only seniority but also merit. And for the appraisal on merits, they have this tabulation which I had shown to your lordships on the last occasion. Now, he was not born in that cadre. He was not born in that cadre. He could not have been considered for promotion to from level 2 to level 3, or level 2 to 3 to level 4, or level 3 to 4 to level 5. That is the crux of my submission. To back up these submissions, my lord, there are a few judgments only I will point out to your lordship. The first judgment is a very recent judgment of the Supreme Court. The reference you want, it is AIR 2024 Supreme Court, page 3256.
AIR?
Let's straightway come to
AIR?
AIR 2024 Supreme Court, 3256. Lordship, let's straightway come to paragraph 98. That's at page 34 of the judgment. May I read? Page 34. Para 98.
Yes.
The various decisions of this court have only developed upon the principles of merit cum seniority and seniority cum merit by explaining the criteria that may be postulated within the framework of these principles for the purpose of promotion. The scope of the aforesaid principles is summarized below. 1. The principle of seniority cum merit, which is the case in our, postulates that 1. Minimum requirement of merit and suitability which is necessary for the higher post can be prescribed for the purpose of promotion. And we have done that. 2. Comparative assessment among the candidates is not required. 3. Seniority of a candidate is not a determinative factor for promotion but has a predominant role. 4. Upon fulfilling the minimum qualification, promotions must be based on inter se seniority. So 1 and 2 are important.
Yes.
Minimum requirement of merit is required. Second is comparative assessment among the 1 and 3. Seniority of a candidate is not the determinative factor, but promotion has a predominant role. So thereafter, I will not go into merit cum seniority. I will come to paragraph 101. Sorry, Palat. Your lordship may straightway come to 110. Paragraph 110, which is at page 36. Thus, the principles applicable to promotions such as principles of merit cum seniority and seniority cum merit can best be described as two ends of a spectrum. They are broad categories or frameworks for promotion and do represent the actual modalities by which promotions are to take place. It is the rules and the promotion policy, along with the intention of the legislature or the selection board, as the case may be, that supplements these principles and delineates the actual modality of how promotion is to take place. Though these rules and promotion policy, the legislature or the selection body specifies the area and the parameters of the weightage which is to be given to the aspect of merit and seniority on the said spectrum. 111. No doubt while construing the rule of seniority come merit or merit come seniority, some of the observations of the decided cases are not uniform. Justice Krishna Iyer held that if the criteria for promotion is one of seniority
Just
come merit,
coming back.
where the Honorable Apex Court quotes with approval the judgment of Justice Krishna Iyer, held that if the criteria for promotion is one of seniority come merit, comparative merit may have to be assessed if length of service is equal or an outstanding junior is available for promotion. Now, here, my lord, pausing here for a minute, my lords. Here, my lords, for comparative assessment, that AFR assessment which is provided in the bank is necessary, which the petitioner did not have. Now, my lords, paragraph 114. While laying down the promotion policy or rule, it is always open to the employer to specify the area and the parameter or the weightage to be given in respect of merit and seniority separately. So long as the policy is not a colorable exercise of power, nor has the effect of violating any statutory scope of interference and other relatable matters. So, well, it's not the case, petitioner's case, that the policy was a colorable exercise of power or anything of that sort. Thereafter, your lordship. The next limb of submission would be that the petitioner was not at all born in the cadre. So he could not have been considered for promotion to scale 3 or 4 or 5. The first judgment on this point, reported in AIR 1991, Supreme Court 1, page 1244. Paragraph 8, my lord.
Yes.
Paragraph 8. The High Court held that no person can be promoted with retrospective effect from a date when he was not born in the cadre so as to adversely affect others. He was not born in the cadre of scale 2, he was not born in the cadre of scale 3, nor was he born in the cadre of scale 4. Next, your lordship may take paragraph 12. In the instant case, the promotee respondent number 6 to 23 were not born in the cadre of the assistant engineer in the Bihar Engineering Service Class 2 at the time when the respondents 1 to 5 were directly recruited to the post of assistant engineer. And as such, they cannot be given seniority in the service of assistant engineers over the respondents 1 to 5. It is well settled that no person can be promoted with retrospective effect from a date when he was not born in the cadre so as to adversely affect others. It is well settled by several decisions of this court that amongst members of the same grade, seniority is reckoned from the date of their initial entry into the service. In other words, seniority inter se amongst the assistant engineers in the Bihar Engineering Service Class 2 will be considered from the date of the length of service rendered by the assistant engineer. This being the position of law, the respondents 6 to 23 cannot be made senior to respondents 1 to 5 by the impugned government orders, as they had entered into the said service by promotion after the respondents 1 to 5 were directly recruited in the quota of direct recruits. Judgment of the High Court. The next judgment on this point is Parallel citation is 2011, volume 1, SCC, page 481.
Two thousand
2011, volume 1, SCC.
No. 2011, volume 3, SCC.
Volume 1, 2011, volume 1, SCC, within bracket LS,
No.
bracket close, 481.
SCC citation is there. Right? Should be.
Yes. SCC, sorry, this is SCC.
267.
Yes.
Yes, sorry, Manoj. 2011, volume 3, SCC 267. Sorry. Para 26.
Yes.
Para 26. This court emphasized in the case of Uttaranchal Forest Rangers Association, so and so, that no retrospective promotion can be granted nor any seniority can be given on retrospective basis from a date when an employee was not even born in the cadre. In this regard, the court relied upon an earlier decision of this court in the state of Bihar, which I just placed before your lordship. Next, your lordship takes para 30. Para 30. From the above, the legal position with regard to determination of seniority in service can be summarized as follows. Roman 3, I is important. Ordinarily, notional seniority may not be granted from a back date, and if it is done, it must be based on objective consideration and on a valid classification, and must be traceable to the statutory rules.
Yes.
This one last judgment.
Yes.
Citation is still labor case. Para 15. Para 15. The pay scales of the sectional officer grade 1 was 4,500 to 7,000, and the junior engineer was pay scales of 6,000 to 9,750, meaning thereby that they were working on a lower yet non-gazetted post. Dispute in the present appeal is only pertaining to the sectional officer grade 1 whose posts were upgraded on 11/10/2007, and not those whose posts were upgraded prior to the direct recruitment while notification dated 1/5/2003. The blatant error committed by the division bench of the High Court is that the upgraded sectional officer grade 1 are directed to be given seniority in the cadre of junior engineers from a date on which they were not even born in the cadre, as it was only on 11/10/2007 upgradation order that they became junior engineers, which was much after the direct recruitment made on 1/5/2000. So it's an important aspect that he has to be born in the cadre for consideration to the next level. And that is on the basis of the policies, statutory rules of the bank, which provides for appraisal on the basis of seniority, so on the basis of merit, which is to be calculated on the basis of AFR scores.
Yes.
ARF scores.
Yes.
Besides that, my lord, there is one more aspect which I just wanted to, which I had just alluded to in my submissions on the other day, which is with regard to that petitioner may be entitled, may claim benefits on the basis of promissory estoppel and or legitimate expectation, because both are based on different rules. Promissory estoppel is a personal right, whereas legitimate expectation is based on public policy. Now, the learned court below, my lords, learned single judge, my lords, has erred in applying both the principles. In paragraph in paragraph 30. If your lordship takes page 13 of the judgment of the learned single judge.
Yes,
The
page,
first sentence of that page. Therefore, the claim of page 13 of the judgment of the learned single judge.
yes,
Page 13 at the top, the first sentence there. Therefore, the claim of the petitioner with respect to violation of legitimate expectation is fortified. The promise, commitment to consider the case of the petitioner year-wise under different channels from 2004-5 to 13-14 has been violated ex facie, and non-adherence to such commitment is violation of principles of promissory estoppel. So, the two things are totally different. One is legitimate expectation, the other is promissory estoppel. He has mixed up both the things. So that is where he has gone wrong. And the other thing which I had shown to your lordship is that table which he has extracted at page 20.
yes,
Now he has quoted the promotional policy as per the statutory rules, but he has not emphasized on the other portion which he has only, if your lordship takes the table, my lords, at page 20, as per the promotion policy, best 4 years out of 5 years AARF marks is for the current cadre, that is MGS 1, are required for consideration of the promotion to MMGS 2 for the year 2013-14 as per the revised policy applicable.
Which paragraph you are reading?
I'm reading the table at page 20 of the judgment of the learned single judge.
Yes,
Your lordship has got the table, my lords?
yes,
The table, our reply. He has quoted the reply of the bank. As per the promotion policy, best 4 years out of 5 years of AARF marks in the current cadre, that is JMGS 1, are required for consideration of the promotion to MMGS 2 for the year 2013-14 as per the revised policy applicable for the particular year, that is 2013-14. Since Sri Pati has not completed 5 years of service as officer of the material time, he was not considered for promotion. Now, he takes only this portion that Sri Pati has not completed 5 years of promotion, and on the basis of his finding earlier rendered that legitimate expectation and promissory estoppel both, he has held that marks have to be awarded even though they are non-existent.
yes.
That is all.
Madam, humble submission, I just want to say that the opposite parties claims all the rules, narrations they have submitted have no meaning because it is their wrong. It is their deliberate wrong which has prevented me from doing this. They say that I was not born into the cadre. How can he be born if he will be back? That is the fraud on their part. So all these narrations have no meaning only on this ground. And just I may quote Justice Iyer in Possibility Venkatasarlu versus the Motor and General Traders, AIR 1975, SCC 1709. But Justice says, equity justifies bending the rules of procedure where no specific provision or fair play is violated with a view to promote substantial justice, subject to, of course, the absence of other disentitling factors and just circumstances. And further, he says, we affirm the proposition that for making the right of remedy claimed by the parties just and meaningful, we also legally and factually in accord with the current realities. The court can, and in many such cases, must take cautious cognizance of the events and developments subsequent to the institution of the subsequent. When I came to the court, at that point in time, I was in scale 2, appearing for scale 2. Or subsequently, I have come to the honorable court for 3, 4, 5, but that is not considered. So that they have been, there is enough proof to show that they have fraudulently and with false affidavits before the court, they have just taken the chance, and I am debarred from the opportunities. So it is their wrong which has prevented me from all these rules. So these are all great things. Now on coming to the other things, previous case they have cited, that case has already reached finality because they have not appealed against. That is, there is no case about that. And my lord, I am going to just show something you to a lordship, but you convinced. Seal cover procedure they have mentioned. In the seal cover they opened. The honorable court, while ordering that judgment, do not have spelled about the seal cover position. So they took the advantage and they seal opened to after 1 year. During this 1 year, they just wanted to manipulate with the marks and the content seal cover, because I have my friends in the department working. They have said me that you have promoted, when you succeed in the case, you will be promoted to CLP directly. But I'm just giving you one example, my lord. Kindly see the
Whether what you are reading was there on record for the learned single.
yes, my lord.
You are reading from which?
No, I'm reading from there because this answer they have given, they are taken from my RTI reply also. Kindly refer to their appeal, page 23. That's
yes.
the seal cover register. They have just given a photocopy of that register portion where my name was there. Kindly minus under last column remarks. The seal cover opening authority, he says, opened on 9/3/2013. Not promoted. Please see my remarks and calculations on the sheet. Initials and 9/3/13. On 9/3/13, the seal cover was opened. The seal cover was kept or maintained or covered, sealed on during 10 years back. Now, seal cover procedure is when a seal cover is maintained, all the procedures, calculations, permutations are made. Final finding is put in the seal cover. The opening authority is only to open the seal and act upon that. How he is making and who have authorized him to make certain remarks and calculations again. So the meaning of that, this is a fraud on the part of the bank. So they have just manipulated with the that is my information. Now they again said that chances. My lord, the single judge upon this question has asked them to supply the proofs that they have called. They failed to prove, they failed to, and the single judge has observed like this. No document has been placed. And current, this is the judgments, para 30 of page 12. In the same my lord, the same their appeal. The single judge observes, no document has been placed on record that the opposite party bank honored its own commitment for considering the petitioner for promotion to 2004 onwards in 13-14. So up to 13-14, they could not have called me, they could not considered me because of their frauds, and my fundamental rights have been contracted. Basing on that, the lordship has given the judgment. Now, third, they have given me a chance in 2015 and 16 on seniority basis. This is the chicanery. Seniority means I have to seniority. There is a I'm just giving seniority case. There is a 10 years eligibility. In 2012, they say I have just entered into cadre, and they have denied me 5 years on 5 years ground. So on 2012, it is 10 years. It will come after 2022, but I am retiring to 19. So can they call me in this sense? And even if they call me on the first of the my promotion date, they are killing my 10 years time for this one promotion, while they are taking away my rights and my claims for all the promotions and for the interim period which I have been granted by the honorable court. What is their chicanery, my lord? And secondly, and for I wanted to accept the case. They say they are not, there is no merit. I wanted to accept the case. To all the, I miscast, but they have devoured me. They have deliberately opposed the with false and fabricated affidavits. That is why I could not be allowed. I have all merits, but my lord, I can show some examples where the opposite party bank has gone beyond its rules to select on merit and seniority, or what they call merit, through either through written tests or through various interviews or both. I am just giving an example of file in additional affidavit on 5/9/22.
We shall not consider your additional affidavit.
And additional affidavit to the first yes, merit department.
Additional affidavit in the writ
Yes, ma'am.
proceeding.
Yes, ma'am.
5/9/2024.
File 22.
22.
Yes.
All right.
Page 54, answer 32A. The circular says that interviews and hires waived. What is the consideration? As para 2, as there will be no interview for promotion to scale 3 in circles where the number of vacancies is more than the candidates. This is their consideration. There is no rule merit. They have time and again violated this principle. No rule, no promotion on merit, no promotion on interview, no promotion on test. They have promoted candidates. I have just given an example, 2013, when they denied me the promotion on the 5 years ground. They have promoted 427 number of employees without any interview, without any promotion, a test. Simply on ARF marks they have given. That is the thing. So my ARF marks is above all in that consideration. That is considered. So these are their frauds. And again,
Don't use this expression fraud.
okay, Mike, thank you. Sorry. In 2003 and 4, they have expressed that you have allowed him to, we have considered case in 2003 and 4, but denied in 13-14 on the basis of 5 years of eligibility and ARF marks. In 2003 and 4, I was disposed in same position. I didn't have any ARF, I didn't have any service eligibility. So how they considered my case and completed a process and say me that I am failed. This is the secondary. This is their intention. What they wanted to keep me back. And again, on this ground also, what they have said, they again want that they will continue to harass me and to continue from further promotions. That is our intentions. And nothing can be achieved by wrong submission to the honorable court. And I plead.
What is wrong submission?
No,
What is the wrong submission? They don't make allegations like that.
The wrong submission, you have not.
Please.
Lastly, I may say that all these principles and rules, they are debarred by law to claim because they have done the mistake, deliberate and contumacious. And that is why they are barred to all the claims. And this is the change in the change circumstances. When I have come time and again to the honorable court for protection of my rights, it is now the duty of this honorable court to protect my rights with promotion to scale 5, salary, pension in right perspective, and also some compensation that is fitting to my case.
Item 29. 29. May seek your lordship to say. I use the 100 times. I'm not prepared.
Yes, as requested by Lord AGA. Just this matter on 1 week.
Not 30. 1 week time.
Hi, sir. BIL.
Yes, my lord, it is. But I am suffering now.
Requested on behalf of petitioner 2 weeks. Yes.
31.
My lords, on behalf of Suman Patnaik, ma'am, 2 weeks time may be granted for final counter.
Last 2 occasions, central government assured they have drafted the counter.
My lord, we have already filed the counter by mail. Today will this my land CGC will serve the copy to Mr. Mahanti. It is already filed by e-filing mode. Hard copy will file in the box and copy will serve to Mr. Mahanti.
DSGI. Odisha submits that a counter affidavit shall be filed today.
Yes, yes, already
Counter affidavit
today,
filed today,
today, my lord.
copy of which shall also be handed over to learned counsel for the petitioner. From Sharia learned ASC seeks further time to file counter affidavit on behalf of the state. Where which opposite parties
4, 5, 6, 7.
has requested list this matter on 2 weeks. Stop. It is made clear that no further time shall be granted for filing of the counter affidavit.
The application filed an IA for amendment. So I think copies are A 168102024. I filed it.
This is a very urgent matter where tender has already been finalized. Work order could not be issued because of the lordship passed the stay order, restraint order.
Have you filed any application for vacating the order of stay?
Yes, my lord, that application has been filed. I have filed an objection, but
And
that
my lord, I'm
unfortunate
common practice because it's a midday meal supply matter, my lord, to the food today. Food that will be a serious disruption if my lord the read petition will not be decided.
No, but there is no interim order at all.
Order dated 24/7/2024, my lord. 24/7/2020.
Please read the order.
In the meantime, the tender process may continue, but the final outcome thereof shall be subject to final result of the present treatment. Present treatment, we cannot issue the work order.
Why?
Subject to.
And we could not have passed such order.
When it's midday meal.
It's a midday meal.
There was a confusion there.
Please, there is absolutely no confusion, and we take care of that
Grateful.
while passing such orders.
Grateful.
Yes.
And for the intervention.
I have no objection as regards to the intervention. On the last date also, your lordship allowed the intervention and given me a liberty to file any objection, if any. I have no objection as regards their intervention. They are the successful bidder.
Your number.
Why do you want to amend the?
My lord, initially I had challenged.
Already filed.
Yes, that is on record. IA 16810.
For what?
Initially, I had filed a challenging a tender condition whereby they have defined the term family and which to include full blood siblings within bracket brothers and sisters from common parents and their spouse. And if you are any of your family member is having any of the relation with regard to this contract, then they are not allowed to participate in that tender. Malad has issued notice. Thereafter, without prejudice, I have participated in that tender by submitting my bid. Now, Malad, while technically, during technical qualification of the technical evaluation of the tender, they now have disqualified me on a ground, my lord, that I have not submitted GSTR 3B. On that ground, they have disqualified me. And this ground is not a condition in the tender call notice. The tender call notice specified that you have to submit GST clearance certificate. That's the only condition, my lord. And in the
all right. So how much time do you want?
I had filed an application for amendment.
Why did you say we have permitted you to participate?
No, but without prejudice, I have participated.
You have participated?
Yes, ma'am.
Okay, yes.
My lord is not permitted.
Yes.
So that amendment I have filed to include my lord prayer that my disqualification that also.
No, but that is separate cause of action.
Yes.
But
grateful.
That is different thing. Here you are challenging the policy There you participated and your technical bid has been rejected. So you have separate cause of action.
That liberty elected, I will.
Your numbers 16490.
16810.
16810. Where is that?
Like G.
Like G.
Flag G.
Yes.
Has been filed seeking amendment in the present date application. And counsel for the petitioner, after some argument, seeks permission to withdraw this application with liberty. File a separate writ application after having realized that the relief sought for through by way of amendment is in relation to altogether a separate cause of action. So, I number so and so is accordingly dismissed as withdrawn with the liberty as sought.
So you had been granted time to file objection to the intervention, which we have already allowed. Now you don't want.
There may be.
File number so and so intervention application.
Doesn't want to file it. So the noting keeps filing.
I have only filed the objection to their IA for vacation.
Counsel for the petitioner further submits that he shall not be filing any objection to the application seeking intervention by the IA number
14378 2024. 14378 of 2024.
Yes. Next. Mr. Counsel, please keep in mind that we don't pass interim orders like that.
Sorry. Item note 33. Today only I have received instruction, your lordship will kindly have a perusal, that only 2 to 3 days we want for finalization of the lease, that mining plan, and mining plan is and for the completion that scrutiny. And thereafter the statutory clearance will be obtained by the petitioner, and we will go for the lease agreement. Execution.
How much time will that take for getting statutory?
Only first paragraph will not see, first paragraph.
These did.
Shall be approved in 2 days. That is the instruction.
They are doing something, Mr.
That's all right, Lord, but my anxiety is it must end with your blessing.
All right, so no issue.
This case must end.
All right. We have a
Not lordship's end, with your lordship. Lordship will bring it to a conclusion. Next week, they say 2 3 days. Your lordship puts it Tuesday or Wednesday.
London AG, Mr. Pandal and AG appearing on behalf of the state has drawn this court's attention to a communication dated 12/12/2024, from which it appears that that scrutiny for approval of mining plan with respect to query in question is underway and is likely to be approved within 2 days. Stop. List this matter on 1 week. How much time? In fact, this is also an area of.
I have to take further time to environment impact.
Therefore, we want to know that how much time does it take?
Mining plan,
in getting environmental clearance.
That will take minimum 1 month because public hearing will be there.
And that road is waiting.
Yes, construction is stopped.
It doesn't totally stop.
Yes.
Your lordship knows that Paradip road means it is one dead trap.
Anyone? Item number
19.
My lord, your lordship gives a date.
19.
Item number 34.
Please, your lordship. Lordship, on the last occasion, your lordship was pleased to pass direction to the, my learned senior, to dispose of the appeal that is pending before the competent authority, your lordship. In the meanwhile, I've received an objection, your lordship, wherein they have stated that in pursuant to the amendments made to the act, the appellate authority has been changed from the sub-collector to the director. Your
Deputy
lordship.
Director.
However, your lordship, after the instructions of the sub-collector, since the act says that the order that has been passed by the Tahsildar has to be referred appeal before the sub-collector, that's why the petitioner had approached the sub-collector. And then the sub-collector had directed to saying that they don't have the power, so the amendment, the appeal may be preferred before the competent authority. However, the petitioner has approached the mining officer, your lordship. I pray that your lordship, that it is well within the power of the mining officer to direct the appeal before the competent authority, your lordship, and the same may be disposed of, your lordship.
In your case, the order was passed when? Against which you preferred appeal?
Your lordship, 25/8/2021.
25/8/2021.
Yes, sir.
Against the order of?
This was the impugned order, your lordship, passed by
No,
the Tahsildar.
Tahsildar.
Appeal file on 6/3/2024.
Just a minute.
No.
And when did you prefer appeal?
8/12/2023, your lordship.
After more than 2 years.
Your lordship,
Yes.
as per the direction of the this honorable court, your lordship.
Just a
I approached this honorable court.
But in page 24, it is written 6/3/2024.
So you preferred appeal on 8/12/2023.
Yes, your lordship.
Before whom?
Before the sub-collector, your lordship.
And under the old provision.
As per the direction of the court.
No, under the old provision.
Old
The
provision.
old
Old provision.
unamended provision.
Unamended.
Okay. So when was that amended?
As per the instruction that I've received, your lordship, it was amended in 24/4/2023, by notification dated 24/4/2023.
24/4/2023. Amended. What is that amendment? Do you have? See that section? Do you remember this section?
46.
46.
Rule 46. OMMC rules.
And when did you file the writ petition? When had you filed the writ petition earlier? This is unamended provision, it seems.
What is the date of amendment?
It was amended 24.
Lordship, keep it to at 2 p.m. I will file the gazette notification. My lord. I also come with the gazette notification. 24. At 2 p.m. I will produce that.
27th December 2022.
Yes, that gazette notification. 7 December 2022. That's it. 22, yeah.
The wheel will lie under the old provision.
46, my lord, now. 46 has been amended. Appellate authorities, Deputy Director of Mines, against the order by
You are relying on this 46(1).
Yes, my lord.
So if 46(1), the 46(1) is in the background of now under the, this cannot apply. Don't know, it will have to be. See, do you have a copy
of this gazette?
Yes.
No.
I'll make a copy. Authority may within 1 month from the date of communication refer an appeal. Refer an appeal in form X against to the conservator of forest.
Yes.
If the order is passed by divisional forest officer, it will not apply. To the deputy director, if the order is passed by mining officer, this will also not apply. To the director, if the order is passed by the deputy director, and to the state government, so and so. So therefore, no appeal shall lie against the order passed by Tahsildar.
Yes, but that we have explained in our affidavit that earlier occasion, the unamended era, the Tahsildar was the competent authority, and that has been substituted by the mining officer. If the mining officer passes, then the deputy director is the appellate authority. But since Tahsildar has passed.
Tahsildar has passed, then
in unamended era. Yes, but if Tahsildar passes, it doesn't say
that. That is the silent. The amendment is silent. Then, my lord, your lordship will have to pass judicial order. Judicial order, my lord.
Judicial order. Want amendment? A judicial order.
Because Tahsildar has been substituted by the mining officer, so mining
Please
officer.
find out and please assist us on this point. You will have to find out the law on this point that if a particular provision prescribes a procedure and later if the procedure is amended, then for considering cases pending under the old rule will be guided by the earlier procedure or subsequent procedure. Examine and then address.
Next week, you'll also make it.
Next week, Thursday. We'll have to clarify. Otherwise, it's a whole lot of confusion. Yes.
Item number 35. I may please. My lord, sir. Here is a case, my lord. Regard to my lord, refund of excess royalty deducted in execution of works. But I would like to draw my lord's attention to the honorable of the order of this honorable court, my lord. See, that is page 1:1, page 15. That is the High Court has, Dismissal Court has given a vivid discussion. After discussing everything, also let down the direction. So, make any glance.
to phase 15, my lord. The employer will work out and issue.
Page 15.
15, my lord. 1 5.
15 of what?
That is the answer 1, my lord. That is running page 15 minutes.
Yes.
Yes, the employer will work out and issue necessary computational certificate within 3 months. Employer minutes, the executive engineer minutes. And within 2 months.
15 of the writ petition.
Yes, ma'am. Yes.
15 of the writ petition.
Answer 1. That is exactly.
Just a minute.
Yes.
Yes, for employer will work. Yes.
Yes, employer. The employer will work out and issue necessary computational certification within 3 months, and within 2 months thereafter, the petitioners may either opt for adjustment of against their ongoing work, or the tahsildar concerned shall recommend for refund from the treasury notes. That is, the crux of the point is what the tahsildar should do. The tahsildar should shall recommend for refund from the treasury direct at 2 minutes. What has happened in this case, mirrors? Let's me kindly have a glance. 2 minutes. That is page 53. Straight I would like to draw mirrors. Kind attention to page 53.
Yeah, the petitions.
Yes, miss. Already there is a direction of this.
The same place.
Yes, miss. There is a direction to get my the refund my amount. What has happened? The tahsildar is playing hide and seek. There is a direction to recommend to the treasury. Instead of recommending the treasury, writing applications to the collector, to the secretary, like that. Here is a letter. It tells 57 is a letter to the secretary. Additional chief secretary. That's everything he has mentioned. That amount of that is the computational amount was also there. Computation certificate done by the executive engineer. The spread before the respondent 1, that is the state government, for grant of the amount. There is no required, but it is he has met this under annex. That is the page 57. That's the for a moment. That's the page 57. Hence, everything is mentioned. I would like to place the last paragraph. Hence, you are requested to place the requirement fund, required fund 13,19,137 for compliance of the order dated 4/4/2022 of the Honorable Court in WPS number so for refund of the application. However, the understanding has been verified. That's the tahsildar has verified the calculation sheet obtained by the superintending engineer RW2 Ganjam Barampur for better accountability.
So what happened after this?
Now after this only this is of the year 2021. I only got
no, forget 2021. Let us come to this.
Yes,
the order which you were reading.
Yes, in this application,
the employer will work out.
Yes,
and issue necessary computational certificate. Yes. So whether this was done or not?
Yes, it was done much earlier in the year 2021, and on the basis of that computation, the tahsildar has given me released this.
When was this order passed?
Yes,
this order of this court.
This order is 4/2022. That is
Annexure 1.
Page 42 minutes.
Annexure 1 is dated.
That is in respect of other cases, all other cases. But so far as my present case is concerned,
two cases have been dropped together in this petition. Two clause of action, two different amount.
Annexure 1 is not in connection with your case.
In general, that is generality. On the basis of that order, in all cases, it is this same order is being extended. Plus, in this order, that is 4/2022. This is the order page 42 is in comparison to my case. The instant case. Page 42.
What is the date of the earlier order?
That is
The first order which you are.
Last order, yes. That is the of the year 2015 minutes, 15. 18/3/2015.
Rohit Kumar Das.
Minus. General applicability.
Huh?
This is of general applicability minutes, because this order, against this order minutes, the state government went to the honorable Apex Court. Apex Court confirmed the order.
Let us see how general was the applicability.
Yes, minutes. That is with respect to minutes. That minutes against that minutes answer, page 15. The 16 is the minutes, the order challenge in the honorable Apex Court. Page 16. That the special leave petition is dismissed. Challenge very strict.
What are you saying? This is general application.
Minutes confined minutes for all minutes, because these are the governing minutes. Governing the field minutes.
Mr. Counsel, see the paragraphs. See the other the previous paragraphs.
Yes.
This was in while determining the rights of those persons. And you are saying you are taking us to that.
Subsequent that has happened, after completion of work, I approached this on report.
All right, let us see what order was passed in your case.
That is page 42 minutes. So kindly have a glance.
Which annexure?
Annexure minutes, page 42. That is the annexure minutes 4 series. That is minutes the order dated 4/4/2022. The order minutes that I have shown your receipt is cited here minutes.
What cited?
That as page 43 is cited. That is
so therefore that is applicable.
Here these are not going to pass.
What order? Was there any counter affidavit filed in that case?
In this case, that.
So whether that judgment is applicable or not, how do we know?
This honorable has given the past honorable. The last may kindly come to that.
We have seen.
Yes.
We have seen the order.
Yes, that's. Lastly, may kindly, I would like to place that considering the page 43 minutes.
Yes.
That considering the contentions raised by the London Council for the parties, and after going through the records, this court is of the considered view that the excess amount of royalty received by the opposite partner 5 should be refunded to the petitioner as per the calculation sheet prepared by the opposite partner 4 in compliance with the direction of this honorable court on 35665 of 2020. Therefore, this court directs opposite partner 5 Tahsildar Digo Pandit.
All right.
Max.
So thereafter, the Tahsildar to determine the amount.
Tahsildar already determined that I prepared 57.
Already determined?
Yes.
After this order?
Yes, madam. Proximate kindly come to minutes that page 57, that is minutes answer 5. For a moment, madam.
Yes, then what happens after this order?
Yes, after this order, minutes, only minutes I have been getting only minutes 2,73,340 out of 13 lakhs minutes.
13 lakh has been determined?
Yes, minutes.
Where is the determination?
Yes, minutes 57, page 57. Running page 57, answer 5, madam. 2/12/2020. Hence, you are requested to place the required funds. This state government is requesting the.
Yes, what is your stand?
Our stand is below, Lordship, kindly see counter affidavit page 6, para 6, page 5. We have issued 2 letters, the Tahsildar am appearing, seeking the executive engineer that please determine the exact amount may be determined so that.
So you have already determined.
No, not
you have determined the amount. The Tahsildar.
No, he has not deliberately arrayed the superintending engineer as party, my lord, in this case. Because the order is honorable court earlier was to the OP number 4 for determination. And now, in 2 successive letters, the Tahsildar said, I would therefore, to the writing to the superintending engineer,
at page 13 of my annexer B by 3, that I would therefore request you to kindly verify the excess deduction royalty amount and reassess the same exactly how much amount will be refunded to Srimati Chaudhary, citing reason for refund of the said amount within 3 days to comply with the order passed in the Honorable Court's order. Thereafter, my lord, in the successive case at page, my lord, 17, therefore the same petitioner also given a copy. Therefore, you are requested to once again to request re-verify the excess royalty amount.
Just a minute, just a minute.
Your superintending engineer says that it had earlier been calculated incorrectly. So
He is
now
not responding. He is not responding.
Oh, 63. On basis of that you are not disputing, page 63.
63. Payment of excess deduction is superintendent. It is way back in 2021, my lord.
Yes, come up with this code thereafter.
Payment of excess deduction of royalty.
What have you taken counter? Why are you not giving? Is there any
Reference to
mistake in
letter
the
secretary. Absence of receipt to intimate that the amount was wrongly calculated.
Please this case on
Refunded.
1 week. Just
Royalty to be wrongly calculated. Yes.
earlier?
Yes.
This case on 1 week. Must Appellate in the meanwhile. An affidavit will be filed by the Superintending Engineer, Rural Works Division 2, Ganjam, Behrampur, with a reference to his letter number 8512, dated 17/12/2021, addressed to the Tahsildar Digpa only, which contains the determination of the excess amount of royalty to be refunded to the petitioner. So stop. He will have to specifically state in his affidavit as to whether the said amount is required to be refunded to the petitioner or not. So stop. He shall also be required to state the to name the authority who is required to refund the amount if payable to the petitioner.
There is
Yes.
some dispute that who is refund.
Yes, ma'am.
Item 36.
My lord, one indulgence. Next, 3 series that letters written by the Tahsildar to the superintending engineer. That also will maybe clarified.
So that is what we are asking, who is to pay? Because
Yes.
he said you apply to the Board of Revenue.
No.
No,
We are,
let him first say.
we are ready. We have expressed our willingness to pay, my lord. Only the figure is there. And as per the government direction, we are at fixed.
It will be open for the opposite parties to ensure that in the meanwhile, the rest of the amount if the petitioner is found to be entitled to is paid to him.
He is entitled to pay.
Yes. But that figure is not coming out from the superintendent engineer.
Whosoever.
One part we have already released in the meantime. But we have said that
The amount which he is entitled, you release that part and then tell us.
that superintendent engineer is to specify. my
Oh,
lord.
yeah.
Yes, ma'am. I'm grateful.
Yes.
Item number 36.
I have already received the counter and already filed the rejoinder matter.
I have not received a copy of the rejoinder.
Give her,
Already filed and served the copy matter.
give her a copy of the rejoinder affidavit. Oh, on the office.
Already filed and served the copy.
All right, give her.
Yesterday, my
Let a physical copy of
37.
the rejoinder affidavit said to have been filed on behalf of the petitioner. He served upon learned counsel, learned ASC, appearing for the opposite parties,
And just admitted. 2 weeks. Yes,
Can be taken up next week, it's a small issue.
2 weeks.
He's praying for
Next week.
Next week.
Item number 37.
Yes.
It has already filed its counter.
We have filed counter.
The first year or the second year, the tender? First year or second year?
The second year.
Second year.
What is it?
This is the asking.
Lordship directed that if we don't file counter by 5/12, we have to pay cost. We have on 5/12 only, we have filed the counter affidavit.
Seeking on lordship for a similar interim order matter, which is also pending in similar matter. Here the issue is when after the auction has been confirmed at a particular price, they have enhanced it, in my case, my lord, unilaterally. And I can show your lordship as against the provisions of the rules, the Orissa minor minerals rules. But in similar matters, the coordinate bench of this honorable court my lord, have passed an order saying that your first year is already completed at the old rate. So please issue them the lease deed for the second year at the rate agreed. However, the extension will be decided by any addition will be decided by your lordships. My lord, I have also given a copy of that order in my IA. But I only was praying if my learned friend, if such order can be passed, my lord, I can continue mining and also the state can also.
So this is the second year.
This is the second year.
The first year matters with there, since you have interim order.
Madam.
So that is still.
That was continuing, yes, madam. First,
Association was there, said that no, they are different, they should not be tagged.
madam, because this is first year, second year. Madam, one case was while continuing the lease, they asked for an extension. They asked for an enhancement. That is one batch of matter. This is another batch of matter, madam, where I have finished the first year.
It has been stayed.
Madam, this is the second batch of matters, madam, where I have completed first
So
year.
he's asking for time or not?
No, I am not asking for
They have
time.
already filed a counter.
Yeah.
Madam, I'm ready for hearing as well.
Tomorrow, Monday, Tuesday?
As well, also, please.
Pending or not? In this interim order was passed,
It is
WPC,
pending, it was there last week.
Sandeep Chanda.
It's also pending.
The batch
So
was
we
there.
can take up both the matters.
When was it? When is it between that? It
also
was
batch of
principal
matters.
say.
Madam, the batch of matters
So
also.
give the list of cases,
I'll give it.
issues involved. And
I'll
then-
give it, madam. I'll give it.
You think you don't have anxiety because that year has elapsed?
Yes, ma'am. That year we have been allowed to continue, and then on cases where.
Principal is the same, so-
Madam, the issue involved is the same matter, that after an auction has been finalized, they have enhanced.
This matter on next Thursday. Along with, can you give?
I'll give all the numbers.
How many?
There must be 4 or 500, as much as I can, madam, I'll give.
Along with so and so, to be taken up at 2 p.m.
Which one?
That.
That कितना number?
All right, it will be listed within first 5 cases. Otherwise, the first half we can take.
Well, grateful. Deeply glad. 19.
19.
Please come with the issues involved so that.
Okay, we will start note.
I'll get a small note, madam.
Start note and date cut.
Last time what we saw, it says liable to be enhanced, but because of your mistake.
No, but I'll clarify. I have filed a counter. I have taken a stand. I will press the stand before Lordship. I hope that Lordship will consider.
Item number 38.
That's the order. CP has been was preferred by them.
Where is the order? Yes.
Yes, sir. I filed a support on Product Development Authority members. Thing is that the Development Authority employees will be entitled to pension as per the pension rule framed by the government. Honorable High Court declared that rule ultra vires. Government went to the Supreme Court and lost it. We requested the government to make necessary provisions for that. Whereas the government has communicated later, I got it from the government. That is matters, government is carving out some matters. Because it will ultimately affect what others entitled all employees working under different authorities, they will be entitled to the government communicated these letter matters in response to our letter, because ultimately matter the rule is to be framed by the government.
Yes. And counsel appearing on behalf of the petitioner has drawn our attention to an order dated 18/10/2024, passed in special leave petition bracketed civil diary number 30536 of 2024, whereby the SLP preferred against the order of this court, violation of which has been alleged in the present contempt application, has been dismissed. So, next, learned counsel representing the Cuttack Development Authority has submitted that in view of huge financial implications arising out of this court's order and subsequent dismissal of the SLP by the Supreme Court, steps are being taken for implementation of this court's order.
Requesting the government to because government is to frame the rule, the pension rule.
Court order for disbursement of pension in favor of the retired employees of the Cuttack Development Authority. What's up? Let so-called reply. We have filed so-called. Let fresh so-called reply be filed on behalf of the opposite parties by 4 weeks.
As a last time, more payment. Government has not been made a party. Government in housing and urban development.
Government is not required to.
Because they are the procurement.
Or what will they do? We will see. Government was a party in the writ proceeding.
Yes.
The writ proceeding government was a party.
The rule has been made set aside. Framed by the government was held at autonomous.
Sir, we are dealing with contempt matter. So we can either punish or acquit those who have been implemented as party. So why do you want the chief secretary to be punished?
No, chief secretary was the district of the chief secretary.
Okay.
My lord, we cannot achieve permission, my lord. Due to sudden health decline, my lord, could not appear at
Which case?
Item 1, my lord.
Last date also you're not there, we have granted time.
My mother is not in good condition in 2 months. I am very in condition.
What is that?
Another 7 days time. First I go to the medical to taking my mother to the hospital and not just come. Another 7 days time may be given, my lord.
All right.
My lord, item 38, my lord, may record in the last chance, my lord, it relates to pension.
No question of last chance, because there is a reason why. Recently, the Supreme Court has dismissed.
Yes, my lord.
Well, I don't know.
Till dismissal of the SLP. Yes. All right, it will be listed.
Public.
Next week.
So this matter is item number 12. no?
Sorry.
Item 12.
But item 39 last.
Just a minute.
After.
Item number 39. Your item is?
Order of number what?
Item 12.
In item 39, my lord, my lord senior is mentioning, he has, lead source, he has filed a reply to a show cause, copy may be sought to us.
I have already served. I have already served. Very fast. I have already served.
What is the order?
Order, my lord, in pursuant to the order dated 14/11/2024, the state government has obtained an instruction by filing an affidavit.
Where is the order which has been violated?
My lord, in contempt petition, order is quoted at page 3.
That order we have filed at annex of A to our counter.
My lord, they have submitted a document under annexure A/5, which has no nexus to my case, my lord.
Sir, counsel, let us see the order first.
My lord, that is the, I have quoted at page 3, madam. My prayer in the repetition, my lord, for engagement under RR policy. my
Very
lord.
difficult, Mr. Counsel. Let us see the order.
My lord.
The entire order you have quoted. Where is the order? Where is the operative part?
My lord, order was passed on 23rd April 2024. I have quoted entire order, my lord.
That is at page 5 of the contempt petition towards the bottom, that is the operative portion.
So what is the order?
This writ petition has been disposed of in terms of the Gosibananda Naik's case.
So what
I
is
have-
Gosivamandam?
Yes, my lord. I have annexed that Gosibananda Naik's judgment, my lord, under annexure 3.
The operative portion is at page 35, my lord. The last paragraph.
Last paragraph.
Payment of compensation under RR policy.
No, payment of my case is something different. In this judgment, the entire policy has been discussed. And in that judgment, it is made clear that the late father of the petitioner was entitled to all the benefits those are due. As for the RR policy, my lord, I have prayed in my writ application for engagement under RR policy. But they have submitted a document which relates to payment of compensation. They have submitted a document under annexure A/5. In neither this letter has been communicated to the petitioners, nor they have complied with, which has no nexus. Only they have filed in a sanctimonious manner, only to avoid the contempt proceeding. And they are fully aware about my prayer that for engagement under RR policy. They have submitted a document, we have already paid. I have not asked any payment.
So which part of the judgment in the other case, 24/6/2022?
In this judgment, this honorable court held that they have issued a notification. The prior to 4/1 notification, those who are residing in a project area, they are entitled to get the benefit under RR policy. That has been quashed by this judgment that this clarification is always prospective. That is not retrospective.
Where is that?
That is
my lord, 34.
Yes, please read.
34, my lord. Such a circular can only have prospective operation.
What is the date of that circular?
Circular, my lord, 2010-2010.
Yes.
Which is quoted in my order of the which I have challenged.
Yes.
2010-2010.
Yes.
Your lordship may kind of a glance that content petition, my lord.
Yeah.
The order at page.
Yes.
At page 4, my lord.
Yes. Then what happened? Then what else is there?
Yes, that clarification has been set aside by this honorable division bench. Accordingly, the suo motu query was made by this honorable division bench, and order has been passed that this writ application has been disposed of in terms of Gosivananda Naik's case. According to the RR policy, I am entitled to get the benefit for engagement.
Where is that?
That is under policy, my lord. You will also kind of glass my writ application. I have page 6, page 26, my lord. That is the policy, gazette notification, my lord. That is the policy of the state government. 26, mining project, employment, my lord. Displaced and other affected families shall be eligible for employment by the project causing displacement. For the purpose of employment.
No, where I'm reading?
My lord, page 26, last paragraph, my lord.
26 of what? Annexure?
That is annexure 2, my in my writ petition. That is not that is the policy.
Okay. Annexure 2, the writ petition.
Writ petition,
right,
page 26.
Just a minute. Writ petition is not there.
It's not placed. Writ petition is not placed.
It starts from page 18.
That writ petition is not there on record. Oh. You should have annexed those documents. You should have annexed the order. You should have annexed the document on which you are placing reliance.
Well, I have already
You in the contempt application.
Content application only I have annexed that judgment of the Gosivananda Naik's case.
Yes, what is your problem?
Well, in Gosivananda case, there is a direction, Millard, at page 35 of that document, Millard.
No, but if it has been held by this court that your circular dated 2010-2010 shall have prospective effect, then why should you deny him the benefits?
Madam, this state government has not denied, madam. They have written a letter under Annexure 2 series to the competent authorities.
Who is the competent authority?
Competent authority, the MCL, madam.
MCL? MCL
Yes, madam. Annexure 2 series, the state government has written a letter to implement this order.
MCL is a party?
Yes, madam.
Have they been noticed?
No, my lord. Your lordship has said that
You should not.
after obtaining the instruction, notice will be issued.
Opposite parties number?
2 and 3.
So and so accepts notice. Yes.
That's all. Exactly.
Yes, sir.
Special notice WPC 18,457/2024 and batch.
Who is appearing for the other side?
Some notice, in fact, I am for the petitioner in that matter.
No. In fact, this matter was directed to be listed on 12th. It was not listed.
It has slipped out.
And therefore, it has been listed.
On special notice, it has come.
Absolutely right.
But may I request maybe on Monday or Tuesday?
You are right. This is what I was going to suggest.
That's actually.
There's a sub-item in that, Millards. It's a fresh petition. There's no notice has been issued in that. If Millards will, I'll take your lordship says, I understand it has come out of turn, Millards. What is happening, Millards? Your lordship will kindly visualize this.
You will take out.
Yes, only thing is that they have issued one more tender, limited tender, where I can't participate, and that takes out a chunk of the work that is assigned to me. So, plus that is what, and I have filed an IA where I have prayed that no such further limited tenders be issued, and that they have done.
All I do is take up. We will take up your.
Then how they do the work?
That's exactly.
And not Monday. Monday I am not here. Tuesday the board is heavy, I think. Wednesday we can take up.
Your lordship will address all these.
Wednesday at 2 p.m.
Correct.
All right. Normally I at 3 plus 3:30.
Also, in order to assist your lordships in a holistic hearing on that day, what I'll do, I'll serve the copy of my petitions.
Please do it.
So they can also.
These matters on Wednesday to be taken up at 2 p.m. So in the meanwhile, the parties shall exchange their pleadings.
In this case, which is mentioned in the press state, no notice, we have not issued a notice on it. I need to file a counter, he has not served a copy.
No, it's not like if Millards issues notice in that matter, Millards, your lordships also will hear on my prayer for entering the application.
Your writ petition is there.
Yes,
I'll hear your writ petition.
Precisely.
Required really issue notice.
Precise.
If you can serve a copy, then possibly on the next date
I can take,
he can accept.
but I can't counterfeit by that.
He cannot.
No, it's Millards counter. Of course, as your lordship will direct, Millards counter. That day, your lordships can direct for filing counter.
We don't know what will we do, what I will be doing in the on the next day.
Copies today.
That is up to you.
Yes.
So even some copies on them,
Very well.
because Matarani Transport is there
Yes.
and the staff officer of
In
MCL
fact,
is there.
Millards, the other two writ petitions that have been filed, they have become infructuous. They have participated in the tender.
We will see.
And
We will see.
yes.
Ma'am.
Obliged.
Permission given.
Supplemental list, supplemental list item number 25.
Gita ठीक number पके.
There are, in fact, my lord, there are two writ applications. One is 3163 of 2022.
P1.
63 of 2022.
Yes.
And in which the petitioners were then working, came up before your lordships, awaiting their regularization after contractual service law. They came up when a rule came into force, prescribing another, instead of regularization, prescribing, mandating that they would have to appear a special case and qualify again. So that rule was challenged and also regularization claim was made. That your lordship was pleased to issue notice but refused to grant any interim order, telling that it will avoid by the result of the writ application. While this writ application was pending, then without prejudice, you can appear in the interview. So we appeared in the interview, and some of us qualified, 7 persons qualified, and the rest were not qualified. And subsequent, as a result of which their services were terminated. In the second application, we challenged the also termination to be safe, even though there is an interim order that it will avoid by the result of the application. But next point we have taken that passing of termination order is a independent cause of action, that is why abandonment causing we filed the writ application. These two writ applications are before your lordship. Unless I place the lot of the first writ application, the question of granting any relief in the second writ application would not arise. So, you know, to be precise and brief now, the sequence of events is 2010. I already submitted a list of chronological events to your lordship. It must be in the 5 minutes. You are letting go into this. Bear with me for a few minutes. In the year of September 2010, my lord, Government of India gave a notification in pursuance of the 13th Finance Commission recommendation to improve the judicial dispensation system for appointment of court in accordance with that 2010 Government of India made a notification regarding creation of post of court manager and allocation of fund to each state, including 16 and 30 lakhs rupees for the state of Odisha. On 21/7/2011, Home Department created 32 posts for the court managers of the High Court and subordinate courts. Then on 8/8/2011, the posts were advertised, and a regular selection was made. Recruitment tests were held, regular selection interview was held, marks were awarded after evaluation. The petitioners and along with petitioners, others also qualified for the post and were given appointment law. That is on 6/3/2012. Then they worked for long 10 years now till 2020. But during the pendency law, during their incumbency, Lord, there are several correspondences in between the High Court and the state government, where the High Court repeatedly asked that regularize this post. Lord, I cannot, I have no access to the records, but I was given to understand also additional posts were also requested in order to maintain the reservation, added to the reservation principles. And the government has repeatedly replied that it is under active consideration for regularization. In between it, the Honorable Apex Court, while dealing with this case, pending for all states, where the state of Orissa was a party, also gave a direction that all court managers working as on date, on the date of the order, should be regularized. In spite of that, when this, without regularization, when this rule came, we have challenged it. Lord, We have taken various grounds, my lord, but one of them would be, my lord, that after, in all other cases, after working for a period, if you have not come through backdoor entry, regularization is your lordship is granting. One, then the second is that the direction of the Supreme Court even may not be a judgment, but is an order under 142, and as per say, it is binding between the parties. And because State of Orissa was also a party before the Supreme Court, that order is binding. Mainly, I will rest my contention on these 2 points. And rest of the things about that claim for scale of pay.
But there is one issue.
No.
You have questioned the validity of the rules also.
Yes.
Can you challenge the validity of rule on the ground of a direction issued by the Supreme Court under Article 142?
Milord, if a law is made to nullify the effect of the order, Milord, I think 142 will have a precedence, Milord. So far as that particular issue is concerned, it may not be a law laid down to be followed, Milord.
Yes.
The appointment letters are not there in the writ petition, they're there in the counter, I think.
No, it's not there. Annexure 3 and 4. Annexure 4, Milord.
No, that is the termination of.
This is not the way. 31 to 3163. Annexure 4, Milord. From page.
No, you are taking out the first writ application. But their appointment letter is not there.
That is there.
Page
57, you will see.
Page 57. 57, you are directed to appear in the
letter of
written
offer.
Inspection
of letter of offer.
Is this a wrong thing?
Initial 4 and
25471 of 2022.
No, that is second 3 of 22.
That is not the first writ application. No. But that has been filed earlier.
Yes, 316322 is the first writ petition.
Okay.
That's it.
I thought 250, oh, that is a later one. All right.
Yes.
56 to 57 to 62.
I got it.
Then when page 63 is after the completion of the training at Judicial Academy, that annexure 5, the following court managers now undergoing training at Orissa Judicial Academy who have been appointed on contractual basis with a fixed honorarium of rupees 45,000 per month and joined on 2/4/2000 except serial number 30 who joined on are hereby posted in the place, that is place of posting. Then let's see, skip over that. Earlier, there was a rule of the contractual employees getting increment and other things, and there was a gap. Also, we came and that period was regularized. That is not based on it. And unless we succeed in getting a relief, main relief, the question of scale of pay increment and the things will become incidental. Then, your lordship will kindly.
Yes.
Come to Madam. Thus, time to time extended, and your lordship can turn to page 128 . Annexure 17, may I please? Well, this is from the Register General of High Court to the Chief Secretary and Principal Secretary to the Home Department. Subject regularization of service of the court managers appointed in Orissa High Court and District Court. In inviting a reference to the court's letter dated such and such and subsequent reminder in court's letter dated on the above subject, I am to say that in the high-level meeting held on 28/9/2015, it is proposed by the court to regularize the services of the court manager, wherein the Chief Secretary undertook to take effective steps in this regard. Till date, no information in this regard has been received by this court. I am therefore to request you to kindly implement the appropriate steps taken in the matter by the state government. 10 my lord. On page 129, your lordship you will see, because there was some problem about the, I am giving to understand that if your lordship calls for the file and go through it, your lordship will be in a position. So I am not making a statement, my lord, but my understanding is that since the reservation, there may be a problem regarding reservation. I could also requested for creation of additional post, my lord.
Yes.
120. In 129, in inviting a reference to the above mentioned letter on the subject, I am to say that the tenure of contractual engagement of the post of courtman going to expire on 30/9/2006 and information regarding the regularization of the services of 32 courtmen as well as for creation of 30 additional post of court managers have not yet been received by this court. I am therefore to request you to kindly implement the decision of this state government in this regard for kind appraisal of this court. Then, Lord, 130 is additional secretary home makes a reference, inviting reference to the letter number such and such of the above caption. I am directed to request that following information may kindly be furnished to this department for compliance of the observation of finance department in this regard. Whether the proposed post of court manager are in addition to the present strength of the contractual court managers, pay and job charter, whether posts are proposed temporarily or on regular basis.
Yes.
Then there is a proposal for appointment of permanent cadre of administrator. So I could decline stating that no, we have already appointed the court manager, so we don't require it. That is 134. The Honorable has to create a separate permanent cadre for administrator for court administration. In this subordinate judiciary has already taken stage in moving to government of Odisha to regularize 32 posts of court manager working presently on contractual basis. The above fact may be placed before the Honorable Minister for kindly.
Yes.
Then we'll have 134 also same effect. With reference to the law department, I am directed to say that Orissa High Court, in order to create a separate permanent cadre of admin for court administration in this owner, has already taken steps in moving to government of Orissa to regularize 32 posts of court managers. Then, my lord, in 2020, in these groups,
yes.
You may look at page 137.
Yes.
Absorption of existing court manager. the existing court managers who were recruited on contractual basis pursuant to the resolution of the government of Odisha such and such may be considered for absorption in the newly created post of court managers on commencement of these rules, subject to their continued utility and passing of suit to be conducted by the committee constituted for the purpose by the Chief Justice. Notwithstanding anything under the criteria heading is the absorption of the decision for one time only after absorption. So this rule came into force, which showed that they will be considered for regularization.
Because of the judgment of the Supreme Court, because of that direction.
Like Supreme Court direction, your lordship will kindly see.
See, if the Supreme Court directs that regularize every person who is working as court managers, it would not mean that whosoever is working is to be regularized.
That date, my lord. It never made a rule for future.
No, as on that date you are right. As on that date, and therefore, there was a scheme under the rules itself that those who are working, they should be regularized.
No, let me place the Supreme Court's order. It is.
Do you want to say something, Mr. Acharya?
Yes,
should I? No, should I? You have a right of.
Your lordship is right. But so far, the validity of the your lordship may kindly look at one order. Let us not be.
No, but Mr. Acharya, let him.
Yes, yes.
Please. You were on the rules, 6-1.
6-1, Lord. And taking your lordship to the Supreme Court order.
Yes.
Which
that is page 357.
Yes.
That is paragraph
Roman 9.
Roman 9.
Yes, Roman 9.
Yes.
Already working at the court, the district should be regularized by
page, your lordship may kindly see 365 running page.
Yes.
Paragraph 12.
Yes.
Apart from what we have stated above, we think it appropriate to issue the following direction, which are the most fundamental and vital features to be provided at the earliest in all court complexes.
365.
এটা ক্ষেত্রে ঠিক আছে Reasoned admission.
Yes, it is 366. All right. No, 365. You are right. Paragraph 12.
Is 370.
Yes.
Roman 9.
Yes.
Sir. Professionally qualified court managers, preferably with an MBA degree, must also be appointed to render assistance in performing the court administration. The said post of court managers must be created in each judicial district for assisting principal district and session judge. Such court managers would enable the districts to devote more time to their core work, that is judicial function. This in turn would enhance the efficiency of the district judicial function. These court managers would also help in identifying the weakness in the court management system and recommending workable steps under the supervision of the respective judges for rectifying the same. then my lord, the services of any person already working as a court manager in any district should be regulated by statement as you are of the considered view that their assistance is needed for a proper administrative setup. This was the direction. So they may not be regularized. They say that who are already working, this has a background now because Supreme Court also called for a report about the performance of the work of the court managers already. And being satisfied, the state government also told that they are working efficiently and
Page 72.
See, Mr. Mohanty, the direction was that their services should be regularized. Beyond that, the rules provide that their services should be absorbed. They should be absorbed in service. Regularization, again, would mean if something was irregular, regularize that. If something was irregular, if they were engaged.
It is nobody's case that the contractual appointments were irregular.
Therefore, the question of regularization would arise if their induction was irregular.
Yes.
Here, in this case, their appointment, their engagement was not irregular. Their engagement was regular. Therefore, therefore, the question of regularization does not arise. The question, while framing the rules, the government, rather the competent authority, took into account the fact that the persons are already working and their services should be absorbed. Absorption is beyond something more than regularization.
Umadevi's case says that irregular recruits cannot be regularized.
Umadevi says irregular cannot be regularized. ML Kesri says what is illegal, what is irregular, and it says that if without following the rules someone has been appointed, that is irregular, not illegal.
Yes.
We are not going into that.
But I am telling that if there was an open advertisement and eligibility criteria was prescribed, a committee was formed, and written test.
See, we are not saying that your appointment was in any manner illegal or irregular. The procedure was followed.
Throughout India, Lord, it was only court managers were appointed everywhere that on a contractual basis.
Therefore, Mr. Mohanty, in some of the cases, in some of the states, without following the procedure, court managers might have been appointed. And in that context, it is the observation of the Supreme Court that their services should be regularized if they were irregularly engaged. It will not apply to cases where the persons were regularly engaged on contractual basis. Job.
I am telling that after having worked for 10 years or more, and having the High Court repeatedly recommending and the government agreeing that there would be a regulation.
And therefore, they are making rule. In the rule, there is a specific provision that your services shall be absorbed.
Recommendation was to regularize 32 persons already working as court manager to be regularized.
Anti-regularization.
And some of the courts may not. It may have a persuasive value. I do not say that it is binding on them. They have interpreted the direction of the Supreme Court and told that no, regulation means without any test, you regularize. I have given the large number of.
Madras, or 2-3 courts, I think.
Ah.
There they have
So
these.
there are only two aspects.
Yes.
According to you, the only reason for striking down the rule should be the order passed by the Supreme Court. There is no other reason.
Like that is one for it is against one direction.
That is against the Supreme Court's order.
That's right. One. Another is that having worked for continuously to the satisfaction of all concerned for 10 years, and in case of other contractual employees, 7 years being the criteria prescribed by the state government, in this case, they should not have been discriminated by.
No, here it is only 6 years or something.
No, it is 12 to 22. 10 years.
Yes.
These are basic formulations,
Next page.
Your Lordship may look at this second National Judicial Pay Commission report, which begins at page 308. I have given the relevant pages.
Yes.
So far as sport manager, it deals with page 311. And so far as this 300 page 312, paragraph 31.4. In most of the states, the regularization of services of court managers.
No, you are reading 312.
312.
Internal page.
Yes, sir.
And the judgment of Kerala High Court.
Running page.
Running page, yes. This is judgment of Kerala High Court.
No. 3163.
Oh, sorry. You are right. Maybe right. Just. Which annexure is that?
Annexure 42.
42. Up to 40. Huh? Rejoinder.
Part of rejoinder, annexure 42.
Yes. Running page 312.
Paragraph 31.3.
4.
Okay. Our running page 378.
376.
No, what is the digital page?
Digital page is 378.
Digital page.
Running page 312.
Is
378.
page 312.
Yes.
31.4. In most of the states, the regularization of services of court managers has not taken place in spite of long passage of time. The directive of the Supreme Court remains unimplemented, though the High Courts have been addressing the state governments in this regard. They continue to work either on a consolidated pay or the inadequacy pay provided for in the rules. Either there are no allowances or the allowances are fixed or quite low. For instance, in Maharashtra, the court manager appointed on contract basis plus allowances. In Rajasthan,
So here, Mr. Mohanty, that is not the case.
Yes.
Here the persons have been regularized.
Where?
Here in Odisha. At least 7 of them.
So after they have been absorbed.
Therefore, it is not that though the persons who were working as court managers have not been, their services have not been regularized or they have not been absorbed.
They are observed after prescribing a suitability test. Yes. My contention is that Supreme Court told that those persons who are already working should be regularized, and regularized means, instead of like the regularization rules so far as contract employees of the state government is concerned, that whoever has all contractual employees completing 7 years are by entitled to be regularized, means they are given without, they are not asked to, those who have completed the required number of service, they are regularized. So question of prescribing another test for regulation, it will amount to a second recruitment. That is my submission, subject to your lordship's acceptance or otherwise. So this judicial commission, finance commission, government and state governments report to the commissions that they are working efficiently and to the satisfaction of all concerned. But after 10 years of service, it is as good as asking me to appear in AIB, All India Bar Council exemption. I am 100% sure that I will fail if I appear today.
No, but your initial enrollment was not contractual.
No, I am telling you, if somebody says that you take a test today after so many years, I am 100% sure that I will fail. I will fail, and these persons passing 5 years, so they will come out with flying colors. I am 100% sure about that.
Yes, I am also 100% sure.
Then another sub point is that in the second read, we have challenged, it said that the prescription of modalities, but that suitability test we have also challenged, in that it has given too much excessive marks so far as Bhaya is concerned. That I will demonstrate to your lordship after 2-3 decisions of the Supreme Court.
That is very, those are very celebrated judgments when they, the Supreme Court says that it should not be excessive. Initially, it was 12.5%, thereafter 25 or something. So, what is the what was the percentage here? 40%. You can give those decisions. You can give the citations of those decisions.
We have filed it and not like placing. And so these are my opening submissions. So not in that got sat. And I will take it. That's it. So,
yes.
I am supposed to make some supplementary submissions.
You are for?
I am for the petitioner number.
In the second case.
The same writ petition 16, 17, 25 and 26.
How the two senior advocates can appear in one case?
Some of the petitioners, they wanted that I should also assist your lordship. They have probably taken no objection.
No.
They have subject.
All right, let us see.
Subject to permits, I can assist.
Yes.
Not,
try to be
very precise. Very precise. I prepared a short note for your lordship instead of taking your lordship to this note. Your lordship can. I have quizzed out the relevant documents from this voluminous brief and for today, Lord. There are two types of matters. One is challenging the disengagement. The other one is challenging the virus, specific rules in the 2020 rules, and also asking for report. If lordship sees this first matter 3163.
So suppose if we declare that rule ultra virus 6.1, based on that rule, 7 persons have been appointed.
They will definitely go.
No, they will be regularized.
Right, they will. They will go or they will not go, that's a different matter. But a decision will have to be taken.
But that's the reason I am confining in the first matters.
But they were petitioners.
Pardon?
They were petitioners in this writ application.
Right.
Now, some of them have been regularized.
They were they petitioners? I don't think.
Some of them were
They should not
petitioners.
petition. Right.
So can you appear against them?
No, we can't. We can't.
But finally, the result may go against them.
That's the reason I have found out one escape route. I am not pressing that prayer number 3 and 2 and 3. My learned senior is pressing, but then so far as me and my petitioner is concerned, those 2 and 3, I am not pressing. I am only prayer number 4 here and disengagement in the other matter. Am I clear?
What is prayer number 4?
4 is to regularize. Am I clear? Well, I'll straightway take your sheet. I'll try to draw a distinction that 2020 rules is absolutely the wings of the entire rule is not applicable to these 32 numbers of court managers who have been appointed against the sanction vacancy following the process of law. My understanding is this. My limited understanding is this. 20 rules is not applicable, and the theory of absorption of these 32, whatever is there in the rule 6, is not applicable to the existing court managers. I mean, those who are continuing against 32 posts. Let me make it further clear. 32 posts were created. Following process of law, they were appointed. Then extension issue arose.
So then 6.1 refers to what?
Yes, that's the interesting. Kindly see, my lord. 6.1 refers to newly created post. Newly created post means one just letter from my restriction letter. Kindly see, the language used. Kindly see, that is at page 137. Kindly see that. Yes. See, just see page 131. The language used here is the proposed post of court managers, the newly created, the proposed posts of court managers are in addition to the present strength of contractual court manager, meaning thereby existing 32, proposed post 30, total becomes 62. Am I clear, my lord, here?
Let me see. You're reading what?
Kindly see. 131. Brief. Of my brief.
Same brief, no?
Same brief. Annex 20. First read. Right. Annex 20, page 131 of WPC 3163 of 2020.
Yes.
That's what it is. Kindly see para 1. The proposed posts of court managers means the 30 posts which were created and in addition to managers are in addition to present strength of contractual court managers. So contractual court managers 32, proposed posts 30, total becomes 62. There is no dispute about this.
So according to you, the rules apply to 30 posts and not 32?
Not 32.
Oh.
That is how the language is there. Kindly see rule 6. And also again, let us revisit rule 6, man. Kindly see. 137. Page 137. Our posts are created in 2012. The existing court managers who were recruited on contractual basis pursuant to the resolution of the government of Odisha in Home Department number so-and-so dated 21st July 2011 and completed 6 years of service in the said post may be considered for absorption in the newly created post of court managers. So this is an...
Just a minute.
Yes, ma'am.
Yes.
Now your Lordship may see, not only that, newly created post of court manager on commencement of these rules, subject to their continued utility and passing of suitability test to be conducted by the committee constituted for the purpose by the Chief Justice. 2. Notwithstanding anything contained in these rules, criteria regarding age and other conditions of eligibility for direct recruitment shall not apply to the appointment by of absorption. That way, so direct recruitment principle is given away.
Yes, yes.
Right. Now now the rules do not provide what will be the manner of suitability test nor what will be the standard of suitability test. Rules do not provide that. The suitability test is not defined anywhere.
Yes.
Now if your Lordship see in the subject, I may be subject to Lordship's acceptance or not. This is what I have understood from reading of Rule 6.
Yes.
Newly created posts means it is for 30 posts, those existing court managers are being considered for absorption. If I fail there, Rule 6 do not provide that I will be disengaged. Rule 6, it's an enabling provision. Rule 6 do not mandate that if a candidate fails, the existing court manager who are prior to newly created posts continue will be disengaged.
Yes.
So they are contractual employees continuing on contractual terms for specific period. That's a take. My learned senior rightly used the word regularization. The reason being that was a tenure-based appointment, not for initially for 3 years, then extended from year to year up to last page is 125.
Yes.
So that is why.
So where is this letter? 21 July 2011.
21.
No, page 50.
21 7
Page
2000.
50.
Page 50.
Page 15.
Annexure 2.
Annexure 2.
And when were you appointed?
But appointed in 2012.
You were not appointed in terms of this resolution, 21 7 2011.
Right. In terms of this resolution. But we are considered, but kindly I am trying to distinguish these two. But question of our absorption against the newly created post, that's a benefit granted to these people. If they qualify the suitability test, they will be straightway absorbed. If they don't qualify in Rule 6 do not provide that they will be disengaged from their existing position.
Let us be clear.
Right, ma'am.
See, you are saying you refer to Rule 6.1.
Yes.
Sorry, rule is an action.
Rule is at page 137.
Annexure.
But that is annexure. Annexure 24.
Not annexure.
Annexure 15.
Right. And one more provision I will show you.
Just a minute.
I'm so sorry.
No, that is group.
Where is the rule?
Can I show page 135?
Yes.
Annexure 34. Contractual 2020 rules.
So 6.1 is where? 6.1 is at page
137, page 137.
137.
Right.
The part of Annexure 24.
Correct.
So 6.1 says
Right.
This is no wrong.
that existing court managers who are recruited on contractual basis pursuant to resolution of the government of Odisha in Home Department dated 21 July so and so and completed 6 years of service in this said post may be considered for absorption. So you were not appointed.
Yes, we are appointed.
Against this?
Yes.
On the basis of this?
Yes, ma'am.
Then how do you say that?
I am saying that this is in view of the word newly created posts. Our absorption will be considered against newly created posts, not against 32 which earlier stood there. Now this I am saying, kindly see page 135. Kindly see.
Yes.
Kindly see that. 32 is not newly created post.
Yes.
Kindly see page 135.
Yes.
1 sub rule 2. These rules, let's got that page 100.
Yes.
These rules are applied to all persons appointed to the service by direct recruitment or by absorption made by the government after commencement of these rules.
Yes. Yes, we have understood.
But now question is, if your lordship will see, there are two things I am trying to advance, Lord. In view of the word used newly created post,
Yes,
my
yes, we will.
32 post will not come within the
All
ambit
right, all
of
right,
rule 20.
all right.
20. My second submission is, referring to rule 6, you are taking away my right of regularization, which I have in terms of, as well known, no judgments, Uma Devi and other judgments. And coupled with that, you cannot nullify my right of regularization, because regularization word is used. Your lordship said that our appointment, since regular, not irregular, question of regulation doesn't.
Uma Devi says what? What does Uma Devi?
Yes,
lay down?
Uma Devi says appointments which are irregular.
Appointments which were irregular,
Yes,
not which will be irregular.
definitely not.
See, Uma Devi, we must keep in mind
Right.
that Uma Devi was rendered in 2006.
6.
Uma Devi does not give a certificate that you allow illegal appointments after Uma Devi, and after they complete 6 years, their services should be regularized.
No,
This is not Uma Devi.
no disagreement.
Huh?
No disagreement with your lordship.
Yes. So Uma Devi applies in respect of the employees who were already appointed prior to that, prior to the judgment. And in that case, the Uma Devi says that in this circumstance, you can take one-time measure. So that is the background.
Right.
Uma Devi
Right.
cannot be a
Based on that, if your lordship will kindly consider, that based on that, the 2013 rules the government has brought in, contractual employees declaration procedure. Those who are continuing on contractual basis on completion of 6 years, they will be regulated. 13 rule will apply to us. If your lordship will see, coupled with this, Lord, I have also a set of judgments. Supreme Court says that under the garb of introducing a rule, you cannot nullify the effect of the judgment.
effect of.
Effect of a judgment passed by Supreme. But that's the settled position. Lord, if your lordship.
See, you are what learned advocate general will be arguing that provision under 6(1) has been incorporated to comply with the order of the Supreme Court.
But to that, Lord, keeping that in view, I have said this, Lord. I appealed at that. Keeping that in view, I am trying to draw inference from that newly created post.
Yes, you have been rather. Initially, I was also I was under the impression that it refers to a particular date.
Correct.
When the posts were
Grateful. Yes.
And had it been your case,
Yes.
that you were appointed because of that against those,
Then
the matter would happen.
If I can show that order only by virtue of which our posts are created, that only document I will show and conclude.
Yes.
I will not take.
All right.
So that's a document that can
Page 50. Page 50.
Page 50. Page 50, annexure 2. This is that. Yes. Kindly similar, page 50.
Yes.
The bottom paragraph. But I'll just resume my whole submission to this word and conclude it.
Yes.
In our state, 30 revenue districts were constituted for smooth functioning of the state and equal number of judges.
No, which paragraph? Page 50?
I'm so sorry, Lord. Page 50, annexure 2, para 2. By virtue
para 2, yes.
By virtue of which our posts are created. In our state, 30 revenue districts were constituted for smooth functioning of the state and equal number of judgeships of session divisions have also been constituted through all, though all are not functional and will become functional in course of time. However, now only 15 judgeships are functioning and remaining 15 judgeships will be opened in a phased manner. Thus, in consultation and as advised by the Honorable High Court of Orissa, it has been decided to carry 32 posts of court managers, each one for 30 judgeships, 2 posts for court managers for the High Court of Orissa. Recruitment and appointment will be made in those 16 judgeships awaiting to function. And when those judgeships are functional, appointment will be made for the said judgeship by the Honorable Chief Justice of the High Court of Orissa. Now, I'll just show one more piece of paper where the High Court recommended for our regular. If my learned senior has already shown it, I'll not repeat it. But that's the only document you Lordship will kindly see. High Court has also recommended for our regularization. And while regularization, High Court recommended our regularization, this suitability test theory was never there. Kindly see that document. High Court Resolution.
Page 129.
Page 129.
Please.
Annexure 17. Yes. May I just please?
Yes.
Annexure 18, page 129. In inviting a reference to the above-mentioned letters on the subject, I am to say that the tenure of contractual engagement for the court managers is going to expire on 16th, and the information regarding regulation of 32 court managers as well as proposal for creation of 30 additional court managers have not yet been received by the court. I am therefore to request you to kindly intimate the district in session 2 in this regard, kind appraisal of the court source. Then, Lord, the same refutation of those letters, page 130, proposal for creation of 30 additional posts. Then the other letter which I have already placed. So to conclude my submission, my lord, this is only that otherwise 10 years of entire career is gone.
We will see.
They are virtually without any, today, they will not be fit for any other job. Keeping that in view, I have tried to draw a distinction in these rules. Should I keep that judgment?
You can.
That you cannot take the violate the Supreme Court, sir.
There is a Supreme Court decision, Lord. In the case of your lordship must be knowing. In the case of Shilpa Sales versus Barun Srinivasan, my lord, 2023. CTC citation. Where they say that of course Hindu Marriage Act provided a intimacy period for mutual consent. Supreme Court told that no, that period may not be binding in view of 142 direction.
No, that is different. That's Supreme Court.
I am telling you, Lord, but though there is a taking that.
You are right. From case to case versus like in this.
That's true. Only taking that analogy, Lord.
Yes.
The Supreme Court decision can be binding.
Yes. In many of the cases, the Supreme Court
because it is a plenary power. 142 is a plenary
power that can be exercised by the Supreme Court.
That is it. And again, I have given a written citations, note of citations, wherein I have referred to those judgments about the excessive marking. They're given around 1987 Supreme Court.
Is that Ajay Hasya?
No, that is Durga
Ashok Kumar. Yes. Ashok Yadav or Ashok Kumar Yadav?
Ashok Kumar.
Ashok Kumar.
And I have also given that note.
Ashok Yadav from Patna High Court.
Ashok Yadav from Patna.
Patna.
It was from Haryana.
Haryana.
I'm sorry. I referred to Ajay as 50%. Mark was given for Bhaga.
Yes, so therefore I was correct. Ajay Asya also deals with that.
And also the other is 12.25.
12.25. 12.50.
Yes. Then Mahinder's sign guard, that is 15%. Munindra Kumar and others, 15%. I have given details.
Later, the Supreme Court has explained that depending on the nature of service.
And the selection committee has no power to prescribe a marks. That those decisions, minimum qualifying mark. Given those two decisions, Umesh Chandra Shukla 85 Supreme Court 1351 87 Supreme Court 2267 and because the rule is silent, what modalities? The selection committee cannot prescribe marks, minimum marks. Yes, that.
All right. Yes.
Yes. Let three aspects broadly. The essentially we not pray three things. Number, they challenge the virus of the rule.
Yes.
Framed under Article 309. That especially Rule 3, 6, and some other rules will not.
Yes.
3, 6, 12, 18, and 19 of the method of recruitment, etc. rules will not 2020.
Yes.
That which was not made in March 2020.
Yes.
And number two, Millard, they pray that they should be regularized with effect from the date of their initial appointment on contract basis.
Yeah.
Let the third is the prayer to regularize the services as court managers following the Orissa revised scale of pay rules 2017. But all those prayers in my humble submission are misconceived. Let me answer one by one.
Yes.
That I would have, your Lordship may kindly turn to Annexure 2 by which the posts were created by the government of Orissa on 21st of July 2011, to which reference has been made in Rule 6 of the 20 rules. At page 50, your Lordship would find Annexure 2.
Yes.
That following the recommendation, because the whole object of the recommendation of the 13th Finance Commission was to reduce the burden of the district courts and the High Court also, Milan, in the discharge of the administrative functions, because they are since Milan required to discharge the judicial functions. So this was basically intended to Milan lessen their burden, to reduce their burden. So for the administrative works are concerned, and the minimum qualification they say should be a master in business administration, MBA degree. So your Lordship may kindly look at under the Finance Commission, Milan, 13th, it was up to the 31st of March 2015, there was the central assistance. Beyond that, Milan, the central government said that it is not our responsibility. If the state government intends for the continuance of those posts, then they should make adequate budgetary provision to that effect. Your Lordship may kindly turn to page 50 of Annexure 2, by which those 32 posts, 30 for the 30 district and sessions courts in the 30 districts and 2 for this honorable court, High Court. Your Lordship may kindly turn to page 51, paragraph 3 of the order.
Yes.
Let's look at it.
Yes.
Page 51.
Yes.
The posts of court managers shall be filled up by direct recruitment on contractual basis. Just a minute. Sir, please. Contractual basis by an agreement to that effect. The method of selection of court managers shall be such as may be decided by the Honorable Chief Justice of the High Court of Orissa. In addition to the direct recruitment with the minimum qualification, as at D below, the Honorable Chief Justice may decide to fill up the post through deputation from employees of government, PSUs, government and semi-government, autonomous bodies, government, etc., etc. The period of appointment shall be for such period as may be determined by the Honorable Chief Justice for each case, which shall not be beyond 31st March 2015. But this was in view of the recommendation of the Finance Commission. The posts were created purely on contractual basis up to 31st of March 2015. Your Lordship may then kindly turn to their appointment engagement, not appointment exactly, in engagement letters, Millard, which your Lordship would find at Annexure 4, Millard, An advertisement, my lord, undisputably an advertisement was made. Applications were invited. That is, my lord, annexure 3, page 54, your lordship would find. Advertisement number 1 of 2011. This honorable court, my lord, issued an advertisement for their engagement, my lord. Your lordship may kindly look at the advertisement also.
Page
my lord, 54.
of your rejoinder.
No, my lord, of their petition
all
I am
right,
referring.
all right.
Many annexures they have given.
Yes,
I am referring to their documents.
yes.
Let's see, may look at
Yes,
page
yes.
53 first, annexure
Yes.
3. Applications are invited from eligible candidates for filling of 32 posts of court managers, 2 in the High Court and 30 in subordinate courts at the district level of the state on contractual basis. That's it. Page 53. The details of the eligibility remuneration, my lord, that is as per the list, my lord, at page 54. Advertisement number 1 of 2011. Degree in advanced diploma, 5 years of experience, that they fulfill those, my lord, conditions and criteria. And the marks have been allocated, examination, etc., certificate documents to be application fee, etc. This is the format. Marks, my lord, they have allocated 70 for this, I think 80 for career, and oral interview, my lord, 10 marks. So your lordship may kindly turn to annexure 4 at page 57. Those 32 appointees, my lord, the terms and conditions your lordship would find at page 59 of their engagement letter. Page 59.
Yes.
That the paragraph 1. These are the terms and conditions. As court manager under the provisions of scheme for engaging a court manager in Orissa High Court and in each district of the state in utilization of the 13th Finance Commission grant are offered to join on so and so date before the Registrar General of the court on the following terms and conditions. That the services is purely temporary and contractual assignment for a period of 3 years, that is up to 31/3/2015, which shall not entail you to claim any regular appointment. This is clearly stipulated. They are fully conscious of this term and condition while they were engaged in the establishment of this honorable court as well as in the establishment of different district and subordinate courts of the state. Premature discharge, the number 2 condition, premature discharge of the assignment without notice shall be lawful, provided Honorable Chief Justice so desire. But this is also a discretion given to the Honorable Chief Justice of the fixed honorarium of 45,000 only per month, without any dearness. Other allowance perquisite shall be paid to you. However, proportionate reduction shall be made on account of unauthorized absence, so and so. So the further conditions will. So the engagement is purely temporary for a specified period up to 31st March 2015. And the third thing is, it is on a consolidated remuneration of 45,000, which has been subsequently enhanced to 55,000, of course. That is not in dispute. But your lordship may then kindly turn to the Government of India's letters, which your lordship would find at annexure 9.
Yes, one seat.
Annexure 9. Employment of court managers under 13th Finance Commission Award evaluation, page 18. I am reading. Page 18.
Yes. Yes, sir.
This was addressed to all, para 5. As you are aware, funds for court managers as per all other components of 13th Finance Commission, page 89, my Lord Justice.
Yes.
Commission are available only up to 31/3/2015, the central government will therefore be no longer in position to fund the scheme. This was under a scheme. It was not a permanent establishment which only came to be created on 1st of June 2021. I'll come to that letter of creation. The central government will therefore be no longer in position to fund the scheme of court managers after the current financial year. In this connection, attention is invited to the communication number so of 10 July 2013 addressed to all states. Copy enclosed ready reference which clearly provides that any commitment on account of court managers beyond 31/3/2015 shall be the liability of the states from its own resources. If after the evaluation, the state will, this is important, if after the evaluation, state government and the High Court concerned feels the need for continuation of these court managers, appropriate budgetary resources may be kept in the budget for the state from 2015-16 onwards. But it is not in dispute that they were allowed to continue on 3 months, 6 months basis by the orders on the request of the this registry of this honorable court. The government have also given them timely extensions up to the letter of this engagement, which came to be passed on the basis of the Rule 6, the criteria under Rule 6. I am coming to that. Your Lordship may then kindly come to the post creation, which was done by the government at annexure 25 at page 152 of the brief. They were created on regular basis with effect from this date only, not prior to that. This was on regular pay scale. Creation of 32 number 152, my lord.
Yes.
My lord Justice. The Accountant General, I am directed to convey the sanction of governor to creation of 32 number of post of court manager, 2 number for post of the High Court of Orissa, 1 post each for the district courts in the scale of, here below the concept of regular pay scale came for the first time. Earlier it was 45,000 initially, then it was enhanced to 55,000. This post shall be filled up as per the provisions, the post shall be filled up as per the provisions contained in the Odisha Senior Court Manager and Court Manager Appointment Rules 2020. The virus of validity of which they seek to challenge. Rule 3, 6, etc., etc. So while creating the post, the government was fully conscious that there was a rule framed by the government, and it is to be filled up in accordance with the provisions contained in the rule. They essentially, let me be fair to this extent, they rely upon a direction passed in 2018 by the Honorable Supreme Court, paragraph 12.9. I think your Lordship must have seen that. Let me read it. That is 2018. All the state governments, this All India Judges Association includes. One aspect I would be failing in my duty if I do not bring that particular direction of the Honorable Appellate Court. That is citation is 2018-17 SEC, page 555.
Yes.
Your Lordship, that is the order dated 2nd of August 2018. Paragraph, your Lordship, straight comment this particular court manager aspect has been dealt with at page 562 of the report, 12.9.
Yes.
If we go by this, there is something, I'll come to that and address your Lordship on that aspect. Professionally qualified court managers, preferably with an MBA degree, must also be appointed to render assistance in performing the court administration. The said post of court managers must be created in each judicial district for assisting principal district and sessions judges. Such court managers would enable the district judges to devote more time to their core work, that is judicial functions. This in turn would enhance the efficiency of the district judicial system. These court managers would also help in identifying the weaknesses in the court management systems and recommending workable steps under the supervision of their respective judges for rectifying the same. The last 4 lines, Peter, are little disturbing, which may support the petitioner's case. If services of any person already working as a court manager in any district should be regularized by the state government, as we are of the considered view that their assistance is needed for a proper administrative setup in a court. Let these 4 lines, my lord, with great respect, my lord, if I submit fairly, that may help the other side, because they are conscious of the continuance of the existing court managers in various, my lord, district and high courts of the country, because all the state governments were parties. The state of Odisha had also filed a counter affidavit, and from time to time their services were, my lord, extended by the orders, various orders of the government. That is on the request of this Honorable Registry of this.
So what is the total number of posts sanctioned?
32 million.
32.
32 what?
66.
No, not at all.
No.
Look, it's only 32.
He is right. He is right. He is right. Those were those 34.
Not one for his district.
Just a
Two for the Honorable High Court.
32 posts are sanctioned.
32 in all.
32 in all. Against that, how many persons are working?
But I think 10.
No, only those who have been absorbed, only they must have been working.
In consonance with Rule 6. Lord, out of 32, how many
must have come in. New persons must have come in.
3 plus 8.
No.
Then I'm not sure, madam.
I don't. New was 11 thing. But they followed Rule 6 while taking up this. So out of this 32, the present petitioners came to be disengaged in 2022 order.
So how many petitioners have been disengaged?
Milord, all those the petitioners, how many?
I'm in 9.
20 million. Huh? In all, I think 20. Yes. 12 have been retained, 20 have been disengaged after the assessment of their suitability. Milord. That is 2022 is the termination order, which they have challenged in the second writ petition. Milord. That is the other one. The second writ petition number. Milord, the connected matter. That is WPC number 25471 of 2022. 25 Sangram Kesari Jena and 17 18 petitioners are in this petition. I think 18. So I do not know the exact number of course, but the counter is not there. How many have been disengaged? The letter of disengagement is there. It is there, Milord. Your Lordship would find copy of the
in the second case, it must be there.
In the second case at page 59. No, page 69, Milord. I'm sorry. Page 69 and it's 10.
In the
Page
second case.
69 and 70.
Which?
The number 2 writ petition 25471 of 2023.
2547.
Yes, 20 have been disengaged. 12 have been retained. 20 have been, Milord, that is the letter dated, order dated 30th of August 2022, annexure 10 at page 69 of the second brief, WP 25471 of 2022, Milord. Total, Milord, 18 petitioners. I think other two might not have preferred to challenge it.
I am the one of the another petitioner, madam. The petitioner especially accepted, there is some item.
That letter says 11 were appointed temporarily. Regular basis by way of absorptions. Second paragraph. After completion.
No, they have been regularized.
Yes,
After completion of the suitability test
11.
held on 6/8/22 and 20th August 2022, the selected 11 contractual court managers have already been appointed temporarily to officiate to the newly created post of court manager on regular basis by way of absorption by court's office order numbers 1. That order is also simultaneous on the same day. This is order number 13488. That is the previous order. Previous order.
Yes.
The previous one annexed 9. By this order, all those 11 persons came to be observed on a regular basis, are hereby appointed temporarily to officiate in the newly created post of court manager on regular basis by way of absorption in the scale of pay of 35,000, etc. in the regular Millard pay scale with the etc. after the creation, because the posts were created in June 20.
So, but again, Mr. Acharya, we come back to the same situation. Whether the statutory rule can be struck down.
No, that on that ground it cannot be struck.
And if that is not struck down, then no relief can be granted. That is the whole difficulty.
The only thing, Millard, if your lordship would go by this direction of the Honorable Apex Court.
No, we have two things in front of us.
Right.
One, an order passed by the Supreme Court, 142, and then subsequent to that, statutory rule.
A rule.
So statutory rule also binds us. That's law.
Right.
And therefore, unless we hold those provisions to be ultra virus under the rules.
No, this can't be. Manamas in that event, Millard cannot be.
It will be very difficult.
That will be difficult. I'm conscious of
You
that.
will have to address. We need to reconcile.
Right. So yes, Millard.
We need to reconcile.
The rule, Millard, as such, Millard, it can't be touched because it doesn't, Millard, fall within the scope and ambit of declaring it invalid. That may be repugnant. You will see to the extent of repugnancy, it may be read down. But so far, so it can't be as such held to be invalid.
Not that easy.
309, Millard, no doubt empowers. The rule making power is there. So rules are, Millard, otherwise if it is violative of Article 14 or discrimination.
No, if you can rely on a decision, rather, if you can. No, let him complete. Yes.
Right.
So if they rely on a decision, if there is any decision which binds us to the effect that if there is any direction of the Supreme Court and the subsequent rule is contrary to the Supreme Court's direction, then whether on that ground the rule can be declared ultra virus or not. Particularly when Mr.
There are some judgments.
No, Mr. There is difference. There is difference. Had that been law declared by Supreme Court under 141, the matter would have been different.
Right.
Here there is a direction under 142. And here and then there is a law. Or
No, your lordship is correct. There are, Millard, enormous judgments that suppose a provision has been struck down as ultra-virus.
Yes.
The legislature reintroduces like that section 33 of the RPI.
So validation.
Right to information.
You
So
validate. Sometimes it happens that the ground on which a provision is declared ultra virus, that ground is taken away by subsequent legislation to validate that law. That is the principle of validation.
Right.
But
So
here,
Millard, yes, lordship is correct. Whether
so let us see.
Similar the factual, so the prayers which they make, Millard, otherwise is not tenable. But beyond law, there is a concept called compassion and humanity. I don't know.
That is,
That would persuade
Mr.
you.
Acharya, see, we don't decide cases
Right.
only on
On
compassion.
compassion. So that
We do have compassion, but
as such, that doesn't apply. That is, they follow the reservation rule and etc. Here, the ORV has not been followed while making this, because the contractual rule they have annexed. If your lordship would permit me, I may take through these rules also. Your lordship may kindly turn to the contractual appointment rules 2013. They lay down. That is on record. They have filed it. That is annexed. 1 second.
first case.
First case.
Yes.
First case, your lordship would find. Jharkhand rule says that this would be regularized. People lordship would look at the
No,
Jharkhand
Jharkhand,
rule.
what about
Yes.
Jharkhand might have taken it.
Right.
Also Kerala.
Group B 126. That's good. They have their own power to make it. 126 page.
So they have framed rules.
They have framed rules.
They're equally, you have Odisha also framed rules.
Exactly, madam. Exactly. Under their
And
rule,
Odisha
they
also
have-
framed rules for absorption.
Right. We have to see in which manner they were recruited, what was their terms of engagement, whether they followed the reservation procedure and etc. or not. What was the requirement, eligibility criteria, the mode of selection, everything they must have considered, taken into account. Because a rule has been framed, it doesn't mean they have. This contractual appointment rule, your lordship would find at page 126, Milord. Sorry, Milord, 82, page 82.
Annex 8.
Page 82. I'm sorry, that is the amendment. But page 83, Milord. Scheduled caste and scheduled tribe, they follow this reservation principle roster also. They'll have reference to the scheduled caste specified in the.
Yes.
Group B post means classified as such by the state government from time to time. This is a Group B post, undoubtedly. So scheduled caste, scheduled tribe shall have the reference to the scheduled caste so and so and scheduled tribe made under Article 341 SCBC. Persons below this reservation category of the existing contractual employee, your lordship may turn to Rule 7. Notwithstanding anything contained in these rules, the reservation of vacancies for scheduled caste and scheduled tribes shall be made in accordance with the provisions of ORV Act is applicable. They are followed. Here, Milord, there has been no applicability because it was purely on contractual basis for a specified period up to 31st of March 2015 under a scheme of the 13th Finance Commission. So from time to time, they have been extended. So without creation of the courts, posts for the first time came to be created in June 2020 on regular basis. So because that has to be met out from the budget of this state. So central government's liability was over from March 2015.
Let us think over.
Yes. In fact, your lordships are correct. That this is an order, Supreme Court's order is Article 142. Unless it's a rules to nullify a judgment under Article 141, it will not be affected. So
that is
the law.
That
the law which I have given is also a law of Article 141 sought to be nullified. So that judgment may not be applicable.
So therefore, Mr. The difficulty with us is, and we will try, we will again request you to assist us because I have to respect the observation made by the Supreme Court and the law framed under Article 3.
Can I assist your lordship by giving one judgment? But I remember it. AIR 2010 Supreme Court 2210 Parad 24. Wherein the judgment is not there and supplied. Swaran Singh's 96 Supreme Court is referred to. That says any action contrary to the court's order is a nullity.
Any action, executive
That-
action
that-
may be
that-
nothing.
that-
Legislative action.
That, any action or?
All right, we will hear you again on next Thursday.
Take note of that cases, All India Bar,
Judges.
Supreme Court Bar Association cases, where the lordships told that all directions made on 142 are plenary in nature and is binding.
Plenary that will bind parties, and that is only for that determination of that case. If subsequent law is framed, then that is the question. See, it would have been very easy for the court to follow whatever direction has been issued by the Supreme Court. The difficulty is because of the rules.
Then will odd, but then we have to make out an arguable case.
Yes.
So that
We are open.
Right.
and one thing about on the date of the passing of that order by the Honorable Apex Court, the state government was there before the Apex Court has fairly considered.
Therefore, if we try to reconcile the order passed by the Supreme Court and the rules, then we can say that this Rule 6(1) was introduced keeping in mind the Supreme Court's direction in All India Judges Association for absorption. But at the same time, the court, it was decided that there shall be some procedure for their absorption. Not
that procedure will not. May I pass
and
on-
therefore, another argument which has been advanced that if the contractual appointments were made without following the reservation rules, then whether all the 32 posts can be filled up based on that disobedience of the reservation policy. We will see. I'm not.
May I pass on another judgment, which says that it may come in handy in second case, termination. That the selection committee doesn't even have the inherent jurisdiction to lay down the norms for selection, nor can such power be assumed by necessary implication.
All right.
Rule-making function under Article 39 is legislative and not executive.
And whether the persons who have been selected, they are required to be noticed, or whether they have intervened.
Is there affected, the required to be noticed?
No,
we don't think they will be affected because we are 20, they are 11. 32 posts are there.
The rule goes and they will also go.
Not been filled up. No, they have not been.
No, that is in the process of being filled up.
No, I that you don't know. He says that it has not yet been filled up.
All right, we will hear. Next Thursday we will hear you again. Please come out.
We have no need for filling of the posts. That's the honorable.
No,
Can be filled up.
It can. We'll come back with some more supplementary judgments.
please help us.
Right. Sure.
One more back.
Next week to this heard. These matters for further hearing on next.
Item number 26.
Yes. This is about what?
It's a tender matter, let's see.
With that final.
That matter, let's see, by memory that will be mentioned, let's see, takes a time, at 2 o'clock. If you're looking into matter of 2023.
Since it could not be taken up at 2, therefore now the court cannot take up.
Feeling hungry.
You are hungry.
Yes, because into Of this matter, I could not launch lordship because
You're nervous?
no, not nervous lordship. I was expecting it to take up 2 o'clock.
All right, take up.
At least Monday lordship, I don't.
Thursday. Hey, I'm not here. Thursday. Yes, any problem?
No, that's all. But it was sorted by the petitioner.
Thursday.
Problem.
As you question.
Thursday, 2 p.m.
2 p.m.
Thursday. Let it come on Thursday, we'll tell.
Let's.
Problem.
Let's.